We can have everyone take their seats. We're going to get started. But again, if we can have everyone take their seats so we can get started. It's 9 o'clock now. Good morning. I'm Mike Green. I'm the Commissioner of the New York State Division of Criminal Justice Services and also Chair of the New York State Commission on Forensic Science. Today we're holding a joint meeting of the Commission on Forensic Science and the DNA Subcommittee to hear public comments regarding familial DNA searching. Now to start with, I want to thank publicly everyone who submitted comments to us for us to consider, as well as all those who requested to speak today. As for the written comments, I want to assure you I have carefully read and considered everything that was submitted. I feel that we received some very thoughtful and some informative comments from a variety of perspectives that will be very helpful in examining these issues around the use or potential use of familial searching. We were able to accommodate all those who requested to present today, and I'd like to thank not only the presenters, but also everyone who has come to listen today. I'd also like to thank the Commission and the subcommittee members who've traveled here through our storm yesterday to participate in this public dialogue. We appreciate your work on both the subcommittee and on the Commission and appreciate you being here today. I do want to mention as well that while we're here, the purpose today is to give everyone who wants to speak on this very important issue an opportunity to speak. So I do not anticipate that subcommittee members or commission members will be asking questions. That's not in any way a sign of their lack of interest in what anyone is saying or in this topic, but it's out of a desire to make sure that we give everyone who wants to speak the opportunity to speak and say the things they want to say. Now, before we start, I also want to remind everyone that this is a public meeting. There is a structure to the meeting. People addressing the commission and the subcommittee have been given a specific amount of time to speak. And based on the submissions, we've created a schedule that we must follow if we're going to get through the large number of requests we have and give everyone a fair opportunity to present. Now, in order to accommodate everyone, we have a time schedule and we have to stick to that schedule. So we have a clock here. The clock will show how much time people have left. When it gets to 30 seconds, it'll turn orange. I'll remind you that you need to wrap up. It's not that we don't want to hear everything you have to say, but we want to make sure everyone has a fair opportunity to present. So, again, we're going to be very strict in terms of sticking to the time schedule. If you're speaking, I appreciate your help in making sure we stick to that. And again, it's not in any way being rude, but we need to stick to that schedule and be fair to everybody. You know, if someone goes over, you're taking someone else's time, and we can't let that happen. We do have staff from our Office of Forensic Services who will help facilitate the speakers getting to the podium. I do want to point out, in the unlikely event of an emergency, there are 2 exits. I believe they're both to the back here, one kind of straight to the back and one off to my left. If there are any questions during the meeting, we have staff here from our Office of Forensic Services. Maybe if I could ask the staff in the Office of Forensic Services, maybe either stand up or raise your hand so people know who you are here. If you've got any questions during the meeting, feel free to find someone from the staff and they'll be happy to help you. And again, to the DCJS and Office of Forensic Services staff, you know, what we're seeing here is the tip of the iceberg. There was a tremendous amount of work and preparation that went into setting this meeting up, and these are the people who did it, so thank you very much. We really appreciate your work in making this possible. I do want to just note as well that If you've taken the time to review the written comments we've received comments across a wide spectrum in terms of people's views and positions on familial searching. And I appreciate that. It's an issue that deserves serious consideration. It's an issue that people have different views on. This process is designed for the subcommittee and the commission to hear and understand all of those viewpoints. And I expect, and we are going to ensure that this hearing and this process is done in a way that all of those views are heard in a very respectful fashion and considered in a thoughtful fashion. So, whatever views speakers are expressing, I would expect that everyone else would give them the courtesy of allowing them to express those views uninterrupted. If you're here to listen, again, I expect that you will allow all the speakers, regardless of the view that they are putting forward, to express their view, and you'll do it without interruption. We're not going to have anyone interrupting speakers or causing disruption to this hearing. It's an important issue. It's imperative that the commission and the subcommittee hear and consider all the viewpoints on this issue before deliberating and making any decisions. And I would appreciate everyone's assistance in making sure that we do that during the course of this hearing. There's a little bit of background. You're obviously going to hear comments today with regard to the issue of familial DNA searching. And I want to just say a few things about the process here and also about substance. With regard to the process, the commission received a request from the Queens District Attorney's Office to look at the issue of allowing the use of familial testing in New York State. Independent of that request, there have also been similar discussions in the past. This hearing today is an early step in that process. The commission felt it was important during this process and early on in the process to give any interested parties the opportunity to express their views. I would note that in some of the submissions, there were comments critical of the time frame that people were given to submit responses. I would note that this is not the only opportunity that will be provided for comment. For example, in the event that the commission and the subcommittee decided to move forward and adopt regulations, there would, by operation of law, be a public comment period in connection with any regulations that were promulgated. But we felt as a body that it was important at the beginning of this process to give the opportunity for anyone who wanted to be heard to do that, and that's why we're here today. I also want to make clear, as I just said, this is an early step in the process of considering this issue. There will be no decisions made today on whether to allow familial searching, and if so, under what conditions. We're here today to listen to the speakers' viewpoints and consider them in any path forward that we decide to take. With regard to substance, New York State has a state DNA data bank that was created in 1994 by Executive Law, Article 49B. DNA evidence profiles from evidence retrieved from crime scenes are routinely searched against convicted offenders who are required by law to provide a DNA sample in the data bank in connection with criminal investigations. When an evidence DNA profile matches a DNA profile of a convicted offender in the data bank, a notification is made to the relevant investigators. This is just one piece of evidence that may be used in a criminal proceeding. Since 2010, a procedure called partial match has been authorized in New York State pursuant to a decision made by this body and regulations promulgated thereafter. During a routine search of the DNA data bank, there will be times when the evidence DNA profile does not exactly match the DNA profile in the data bank, but is similar enough that the evidence DNA profile could be from a relative of the convicted offender. In these cases, New York State's partial match policy sets out a specific procedure that must be followed before any information from the databank can be released. When it is released with the explicit instructions that this person was not the contributor of the evidence sample, but it could be a relative. Specific instructions are provided regarding the appropriate use of this information. It is clearly stated that this lead is not evidence of guilt and is only a potential investigative lead. Familial DNA searches present a much more targeted approach. They do not occur inadvertently like a partial match does. With a familial search, a specific validated computer program performs a kinship analysis between the evidence DNA profile and all of the DNA profiles in the data bank. There are approximately 10 other states that allow familial searching, and they have adopted protocols regarding how the testing is conducted and what procedures and safeguards must be followed before any information can be released. As I previously indicated, today's forum is designed to elicit comments. Both of the bodies here examine whether New York State should use familial searching, and if so, under what conditions and with what safeguards. Now, with that general background, I'd like to move forward so that we can get to the public comment portion of the agenda. So the first order of business would be a review and approval of the meeting agenda. There have been some changes to the agenda. Some members of the public who requested to speak have subsequently informed us that they did not plan on speaking here, but wanted to rely on their written submissions. One speaker has also been added to the agenda. Everyone has been provided with a copy of the agenda. And just as a matter of process, we need to have both the subcommittee and the commission vote. So I guess first, with regard to the DNA subcommittee, is there a motion to approve the revised meeting agenda?
So moved.
And do I have a second?
Second.
All right, all in favor?
Aye.
Right, anyone opposed? All right, that motion carries. With regard to the commission, do I have a motion to approve the revised meeting agenda?
So moved.
All right, do I have a second?
Second.
All right, all in favor?
Aye.
Anyone opposed? All right, that passes. All right, thank you. All right, our first speaker today is Mr. Phil Vautrin. Mr. Vautrin, before we begin, on behalf of everyone here, both the commission and the subcommittee, I would like to express our most sincere condolences for the death of your daughter. Our thoughts are with you and your family at this difficult time, and we thank you for taking the time to be here with us today.
Hello, everyone. I'm Phil Vautrin. Karina is my baby girl. Karina is the reason we are all here today. She wants they said hello instead of goodbye. It's because there are no goodbyes. There are no Merry Christmases, and there are no Happy New Years. There are many families that are in the same situation as my family and myself. That cannot be changed. But we could prevent other families from ever being in that world. Yes, FS testing will not only help solve countless cold cases and help bring closure to grieving families, but will also prevent crimes like this one. Criminals might not be very smart, but when it comes to how to avoid law enforcement and escape under the radar, they're very learned. A criminal whose DNA is somewhat ashamed. I'm embarrassed for myself and all others that call themselves New Yorkers. New York is the center of my work. Most of the world looks toward New York and follows its example. New York is Rome. But in the case of familial DNA testing, we're far behind. I need not mention the other countries that are much more advanced with DNA research and practice, because everyone here knows who those countries are. I need not mention the 10 other states that already do FS testing, because again, everyone here knows who those states are. And everyone here knows the rate of success using FS. 41-year-old cold case involving the wife of Bill Dna. So New York has decided to take a back seat on this issue. Yes, there was a decision that has been on the table for 8 years, and it has not been acted upon. It has been ignored. Why does it take a horrific crime to get us here today? Why does a victim's parent have to work so hard during a time when they should be grieving for the loss of their beautiful daughter? This is going to happen. FS testing is going to be done in New York, and it is going to happen today. We cannot be stopped. We cannot be slowed. We will not fall. This is a movement created and controlled by Karina. We will be the 11th state that does FS testing, and those close know the significance of the number 11. It's a movement that has the power of the angels behind it. No one here can win a fight against our angel. And it is a fight. It is a war that I have been chosen to lead. Believe me, I would rather be anywhere else doing anything else than here. But I have been chosen, and I take that selection very, very seriously. Law enforcement needs its tool. Every day, it gets harder and harder for them to do their job. And their job is for the good and protection of everyone in here and their families. How many more victims do you want? How many cases do you want to go unsolved? Yes, I'm referring to you because you, the people here today, are the ones that make the decisions. You have the power, and along with the power comes the responsibility. So to speak, the blood is on your hands. I'm going to leave you all here today with a small request. I'm asking every one of you right now for just one moment. Close your eyes. Now picture yourself going home tonight, putting the key in the lock and opening the door. What you see in front of you is someone you love laying dead on the floor. If you just did what I asked, you had an agonizing pain in the pit of your stomach. I ask you, what would you want to be done to find the person that just ruined your life? And I'm going to answer that question for you. The answer is everything they can. Let's do everything. Thank you. I want to introduce my wife, Kathy Vautrin.
Thank you, Mr. Vautrin.
Good morning. In the event that some of you here in attendance are unaware, the murderer of my beautiful daughter was arrested last Sunday, February 6th, by our most finest New York Police Department. I bring this up because I need to stress that in our personal tragedy, in reality, familial DNA is no longer our fight. But despite the fact that I can barely walk out the door every day, I came so that I can represent and honor my daughter and still continue this fight. Since this most heart-wrenching loss of my daughter, Karina, I am no longer living. No. I only exist. I survive each day with a ton of bricks on my shoulders. But my devotion to this mission of allowing Familial Dna Searching brings me the strength to come here today. My husband just requested you to imagine opening your door and finding your loved one dead. I'm not sure if any of you actually did do that, but for those of you did, I'm certain that it was a very difficult visual. And although this pains me more than words could tell you, I'm going to be more specific in respect for my beloved daughter and all victims who are walking in these wretched footsteps. I implore you, just sincerely close your eyes for a moment and imagine your child, not only dead, but beaten and battered and assaulted and strangled. And you can't do anything to help her. And she's gone forever. It's unthinkable, isn't it? It's incomprehensible. It's unfathomable to truly picture this. And yet, this is what actually happened to us. It really, really happened. It's not something on TV. It happened to us, a regular, normal family, just like every one of you here. This is our reality now. And to all other victims whose life ended in this horrible, horrible way. For 6 months now, day in and day out, this vision torments me over and over again. I imagine her absolute terror, the pain that she endured at the hands of a monster. There's no medication, there's no counseling or prayer that will ever heal my shattered being. We, the mothers of a murdered child, are in a prison that we'll never get out of. We'll never get out of that prison. And I don't need to tell any loving parent here how angry we feel from day one of our child's life, anytime they're mistreated. Be it a bully in the schoolyard, or that boyfriend or girlfriend that broke up with them, it breaks your heart, and you're enraged. You all understand what I mean. So then imagine what a mother feels when the absolute, ultimate tragedy that any parent fears actually happens. And despite the most dedicated efforts of the most experienced team, known as our finest, our esteemed NYPD, despite they can't find the demon who mercifully killed their child, even though she fought and she spent the last moments of her life doing that so that she could give us her killer. This is where I have to stop reading because it's confusing. And I ask you, please, to bear with me because I may repeat myself. And I do need a drink of water. When your murdered child fought to get the DNA, or even if they haven't, when we're left with that gift, if you want to call it that, to find this savage. And unfortunately, he's been able to evade having been matching. When that happens, your heart is breaking. Your frustration is something that you can't even begin to understand. And that there would be anyone that would try to stand in the way of finding that person when there is an absolutely proven, utilized method to even give you 1 ounce of help, and someone is opposing that, it's deplorable to me. It tells me that despite your education, whatever your journey in life was, your life experiences, your profession, your jobs, it tells me that your child was not brutally murdered, that your child didn't fight the last moments of their existence on earth, didn't fight an evil monster. And it tells me that if you have been in that situation and you're still saying that there's any reason whatsoever that you wouldn't demand for the use of a tool that could help you, then it tells me that you have no respect for your child. Because as far as I'm concerned, and the army that stands behind me on this, there is absolutely nothing that any loving parent would demand to find the killer of her child. Because all your reasons, all your arguments are trumped by the murder of your child. I have sorrow beyond sorrow for all of us mothers and parents and loved ones that have been victims in this type of tragedy. And to my opposers, I have just one last thing for you to ponder. Are you willing to sacrifice your beloved child to be the victim, the next victim of a brutal murder or rapist that could have possibly be found using this valuable, proven method to possibly find their killer? Are you willing for that to happen to you? And despite what you think or what you don't consider, it could happen to you. It could happen to you in a blink of an eye. It really, really can happen to you. Thank you.
Thank you, Mrs. Vautrin.
Good morning. I'm Karina's cousin, Maria. Karina was a shining star in the lives of all that she touched. She was kind, compassionate, brilliant. She accomplished a lot in her short time here, but had intended to do so much more. I started a petition on change.org for Familial Dna Searching to be approved in New York for Karina's case, but all unsolved murder or rape cases. What prompted me to start this petition is that our family is broken. Her mother, father, sister cannot even begin to heal. Her grandparents, aunts, uncles, cousins, and friends are devastated. Knowing that there is an effective tool available, known as familial DNA searching, that could possibly bring criminals to justice and remove savage beasts from the streets, but cannot be utilized because it is not legal in New York, prompted this petition. Cases should not go cold. Victims and their families have the right to justice. We currently have over 34,000 supporters on change.org and an additional 100,000 handwritten signatures is supporting this petition for familial DNA searching. Familial searching is an attempt to detect potential relatives of a DNA profile already in the database. Parent, child, sibling, or possible other blood relative. Police can then narrow down the investigation, and this could lead police to an ultimate suspect. To be in the database means that a crime was committed by the person in the database. Now the police narrows down their search by focusing on relatives of those criminals. This can help law enforcement solve crimes that may not be solved otherwise. Let's join the 10 other states. Let's be number 11. Familial searching has been used successfully to solve many cases. Phil mentioned Karen Class' case being solved. There was also the Grim Sleeper in LA, convicted serial killer Lonnie David Franklin, who was responsible for a string of murders in the 80s. His son was in the system for having been there for felony weapons possession. In Ohio, Justin Christian, a child rapist, breaking into homes, kidnapping and raping children. He was found using familial DNA. His half-brother, Jimmy, was in the system from having been convicted. Why is it so easy to protect the criminal and yet allow the victim's family to suffer and not use any available tools to attain justice? Any means available must be used to identify a murderer or rapist for the sake of the victim and the family. The Civil Liberties Union feel that it is wrong for family members to be investigated by police when they did not commit a crime. They say familial DNA searching violates the Fourth Amendment constitutional prohibition of search and seizure, and also that it would target low-income and minorities. I say it is a right to feel safe in society, and if familial DNA can provide this by taking a murderer or rapist out of our society, then so be it. Perhaps if familial DNA searching were the norm, it would decrease crime, as possibly the criminal may not commit a crime if they knew there were a higher chance of being caught. Concerns of innocent people being targeted, well, Karina was an innocent person targeted, as well as the many other innocent joggers and people that have been raped or murdered. Some proponents may say that everyone's DNA should be in the system, but that's a discussion for another time and place. We are requesting that DNA that is already in the system be utilized to identify relatives of the criminals that already exist in the database. Some say this is an invasion of privacy. I say that the commission of crime is the ultimate invasion of privacy. Many articles state that 40 to 60% of the prison population in the U.S. have close relatives that have been incarcerated. This indicates that use of familial DNA testing, rather than being a random search of the population, narrows the search to suspects with relatives in the database. There are many comments of support on the change.org website, and I urge you to visit that site. One of my favorites is a person said, here in California, familial DNA testing has been implemented since 2008. This is groundbreaking and needs to be accessible in every state in the U.S. Why are we so worried about protecting the criminal and not the victim? It's mind-blowing. Get it together, New York. Another supporter said, if you can use a tool to help solve crimes, why is this even a question? In the interest of time, I have to say it is paralyzing and painful to be a family member of a victim, knowing there is nothing that you could do to alleviate the pain and loss of Karina. But there is something that this committee could do to alleviate some of the pain and allow families to begin to heal by approving familial DNA searching so that they can have justice for their victim. Rosary Carlino.
Thank you.
Hi, my name is Rosary Carlino. I'm Katrina Petrano's cousin, and I'm going to try to speed talk here. The ability to use familial DNA is imperative from both a legal and moral standpoint. I understand there are many concerns and considerations. Because a familial DNA investigative lead is less direct proof of an alleged perpetrator's profile in the database, familial searching should be viewed as a supplemental investigative tool, in that it's generally pursued when the database searches for a direct match to the alleged perpetrator have been unsuccessful. Should New York decide to implement familial DNA, a formal policy should be established that includes the types of cases that may be eligible, for example, serious or violent crimes. DNA databases should be governed to strict use and disclosure restrictions only for acknowledged law enforcement purposes, such as criminal identification and the identification of missing persons. DNA profiles in law enforcement databases are identified only by a specimen ID number that indicates nothing about a qualifying person's race or any other personal identification. When an initial search occurs, the lab conducting the search will know nothing about the person whose profiles are searched for kinship associations, including their names. There's no ability to specify a particular race as search criteria. Information concerning the results can raise additional sensitivities, but security measures should be vigilant and data safeguarded, limiting who receives the names of familial leads. Law enforcement officials should be provided with sensitivity training, and this is an extremely important thing to have, although there are privacy concerns and security concerns, there are means in place to satisfy them all. I have more to say, but I'm out of time. Thank you very much.
No, thank you. We appreciate your comments. I believe next we have Dorothy McCluskey. And to all of the family members, thank you. We appreciate you being here today.
Good morning, and thank you for allowing me to speak today. It is exactly 18 years ago today at 10:20 that I would become the victim of a horrendous violent crime in my home in Howard Beach with my 15-month-old son. We were beaten badly. The person who was in our house put a gun in his mouth and threatened to blow his head off. Did I not comply with everything that he wanted us to do? It has been a terrible 18 years for me to get through this as the victim of a violent crime, but not only as the victim of a violent crime, but to witness my child at the same time be a victim of that crime. He was a serial criminal, for lack of a better word. he was out on parole. Had at that time, there were 6 of us. It was not just myself. And it was at the time, it was a very, very big case because there were so many of us involved and there were so many children. It went on for a year before they caught him. I was his last victim. I was also his most vocal victim because I just couldn't imagine what it would be like not to know who did this to me and my son. Even though I was able to see his face and give a description, we could never find him. It took from the time that he started until me being his last victim 1 year. At that time, 6 families and their children were a part of this criminal's violence. So today, just as the victim of a terrible violent crime, at that time, had DNA been enacted, never mind familial DNA, we would have caught him, and I wouldn't have been a part of that. They would have caught him immediately. So I am begging you, as the victim of a violent crime, whose life has never been the same, and I am a very strong person, so I can't imagine the other victims, how they've gotten through. Every day I turn the key into my house, and every day I wonder, is there going to be somebody behind that door? Someone who's going to harm us. Every day I go for a walk through my neighborhood, which I represent as a civic leader, and wonder, is something going to happen to me? I forge through my life because I need to, because I cannot be afraid, because I need to speak for the other victims who cannot speak for themselves, victims who did not make it out alive. By the grace of God, we made it out alive. By the grace of God, my son turned 19 in October. But we need to be able to catch these criminals who do this. They need to be held accountable for what they do to families. They need to be held accountable to society. And if the way that we need to do that is to search secondary databases, well, then that's what we need to do, so that families like myself and the Vautrinos never, ever have to go through what we've been through. And I just want to thank you for your time. I know you're all aware of the statistics and the states that use this, but I just wanted you to also see the face of a victim who survived and her child survived. Kathy Vautrin and I have been friends for 31 years. The day that, the afternoon when she came over after I was assaulted in my home and held hostage, she came over and she hung an angel on my door so that when the door opened, I would hear the chimes go and that I would be less afraid and that the angel would protect me. Never did I think 18 years later that I would be holding her hand and we would be walking through this together again. So for the victims everywhere who cannot speak for themselves, please allow this method to be used so that families do not have to suffer like we have. Thank you.
Thank you. We have Tina Cardy.
Good morning. My name is Tina Accardi. I'm a family friend of the Vautrinos. I'm a resident of Howard Beach. I'm also a licensed New York marriage and family therapist. I'd like to thank the commission and the subcommittee for letting me speak for a few minutes this morning. Karina and my daughter are the same age, and they were classmates from the time they were toddlers until college. Karina was a beautiful, strong, athletic young woman. She had achieved so much in her young life. She earned a master's degree in speech therapy, which most people know is quite difficult to do, and she was planning to start her career helping others. She loved to travel, and she also loved her neighborhood. That one day last year, she made a choice to go for a run in a park that borders our neighborhood. This was a run she had done many times before, so she did not feel there was a threat to her safety. She was a victim that day of a depraved, evil person, something she didn't deserve. After 6 long months, her killer has been arrested. After such a brutal crime and a long, intense investigation, her father found out that an additional DNA test, the familial searching, could have been used to find who killed her, but that New York does not yet allow this to be performed. Of course, forensic testing was performed on the DNA evidence found at her crime scene with no match in the CODIS database. Investigators in up to 10 of our states and countries, including the UK, Netherlands, and Australia, are able to use this tool with positive results, solving violent cases, missing person cases, and also exonerating wrongful convicted persons. This is known as a viable method and means to try and solve some of these hundreds of thousands of unsolved crimes in our national database. And many states have had success, as others have mentioned, in apprehending violent criminals. As a licensed professional, I realize there are ethical considerations when taking or looking for people's DNA. Different states, as well as the UK, adopt safeguards in this regard and have ethics committees who are continually involved with protocol with this testing. I recently spoke with a friend of mine in England. She's a homicide detective with the Scotland Yard. She told me familial DNA testing is used to identify both victims and suspects, and a person's DNA is taken and kept for any, running out of time, okay. I would like to say, we'll skip the thing about the English, but this has been used. It's used in different states. Different people have been found and crimes have been solved. Different states do look at other states that are already using familial DNA searching, and they use testing and researching on how other states do it to find ways in their own states. As constituents of this state, we, along with Karina and her family, plus a long petition of people, request this DNA testing be allowed for violent cases where the criminal is still at large and may cause harm or death to more of our population. We hope the committee sees the benefits for making changes to the state regulations to permit familial searching. We pray for full justice for Karina. Thank you.
Thank you. Our next speaker is Assistant District Attorney Eric Rosenbaum from the Queens District Attorney's Office.
Good morning. Once again, my name is Eric Rosenbaum. I'm an Assistant District Attorney, and I'm Chief of DNA Prosecutions for the District Attorney of Queens County, Richard A. Brown. I'd like to just note that I'm accompanied here today by the Chief Assistant District Attorney from Queens County, Jack Ryan, as well as the Executive Assistant District Attorney for Legal Affairs, Robert Masters. The District Attorney couldn't be here today, but he asked that I share the following comments of his with the Commission on his behalf. At the outset, I would like to thank you, Mr. Chairman, and your colleagues for having agreed to consider the authorization of familial DNA searching in New York. As you know, the technique is currently used in nearly a dozen other states and other countries, including the United Kingdom and the Netherlands. It's proven to produce leads that can break cold case murders, rapes, and other serious crimes. It reliably can generate leads that enable law enforcement to identify the guilty, but the technique can also, importantly, help ensure that the innocent will not be wrongly charged, let alone subjected to prosecution, conviction, or sentence. Why we've been asked in the past days, are we still pressing for familial DNA searching if an arrest has been made in the murder of Karina Vautrin? After all, it was the vicious killing of this young woman that first drew our attention to this modern tool of DNA technology. And it moved us to press the Commission to take up the issue. The answer is simple. We are grateful that with the arrest last weekend, the Vautrin family may find some very small measure of comfort in knowing that a suspect has been apprehended and is being prosecuted. However, while the public can rest easier knowing that a suspect is in custody, there are countless other horrible crimes that remain unsolved. Those victims and their families continue to live in fear. The public remains at risk of those perpetrators striking again, and that simply isn't right. Law enforcement must be provided with the newest tools and the latest technologies to do their jobs to solve those cases too. In my judgment, familial DNA searching represents sound public policy. Prudent, appropriate, limited safeguards can be put in place to ensure that familial DNA searching is used thoughtfully and not indiscriminately, and that information generated by those searches is handled with sensitivity. With such protections, familial searching would bring to New York a potentially life-saving, crime-solving tool that is being fairly employed in many other jurisdictions already. From a practical standpoint, as many of you are aware, familial DNA searching is no more invasive of a citizen's privacy than standard criminal investigative techniques that have long been employed without controversy. For example, consider a bank robbery where a partial license plate number is provided to the police from the getaway vehicle. The police run that partial plate through databases to generate a list of cars with plates that are similar enough to be potential matches. Do the police then rush out and accuse or arrest every car owner with a partial plate match? Of course not. Is it fair to call those leads false positives? Of course not. Each of those leads is a candidate match to be investigated as a lead, nothing more and nothing less. The same would be done were familial searching to be authorized. Now, as for any critics from whom you may hear, let me simply say this. Many of those who argued against crime-stopping DNA advances in the past will no doubt argue against the use of familial DNA searching. They will portray unrealistic, ill-informed scenarios depicting the compromise of privacy rights of our citizens if this tool is employed in New York, and that tact is not new. Indeed, all of those doomsday scenarios were posited when this commission was considering the use of partial match reporting in 2011, as well as each and every time the data bank was expanded to include more crimes, until eventually it included all crimes in New York. And yet, despite the dire concerns advanced by opponents at each of these junctures, none has in fact been borne out by the reality of our experience in the last 17 years of using the DNA databases in New York. To the contrary, DNA databank advances like these have led to thousands of convictions and resulted in the exoneration of dozens of innocent New Yorkers. And it is critical to remember that these DNA advances also prevent future crimes. They help take murderers and rapists off the streets before they can brutalize yet another victim. For instance, the 2008 expansion to include all felonies in the DNA databanks almost immediately resulted in the arrest of a Queens man and the successful prosecution of him as a serial rapist. His name was Richard Thomas. He brutalized a child in a sexual assault home invasion in 2004. And what we learned when we ran his rap sheet after his eventual arrest was that the crime against that child could have been prevented had the full potential of the DNA data bank been authorized earlier. Familial searching is simply the latest advance in forensics to come before the commission, and like prior advances, it will surely produce similar results without harm to the public or jeopardizing anyone's constitutional rights. We are cognizant that there is concern in some quarters about the manner in which familial searching leads will be investigated and whether these leads will be handled with the sensitivity that the public expects. I believe that with some simple and reasonable safeguards, our law enforcement agencies we'll be able to maximize the usefulness of this tool and the fresh leads it generates to solve serious crimes while respecting the privacy rights of individuals. The approaches of other states here already using familial searches are instructive. They've provided a sort of laboratory for us of what works. Some have opted for cumbersome procedures and layers upon layers of new bureaucracies, unduly complicating the familial search process and application of the leads. Others use a more streamlined protocol that apparently has been just as effective in ensuring the careful and efficient use of this tool. Therefore, if authorized in New York, I would suggest that the simpler, more streamlined approach be taken. Indeed, the current procedure for the handling of partial match reporting in New York is an excellent blueprint for how familial search leads could be conducted. After all, although a partial match is an inadvertent discovery and familial searches are intentional efforts to discover near matches, the leads generated from either method stand in essentially the same posture from a policy perspective, and from a practical perspective would be investigated almost identically. I'm persuaded that the appropriate safeguards for employment of familial searching would be to require the local district attorney and the local law enforcement official to make a joint application to the laboratory. This would ensure coordination and consideration of both the necessity and the potential benefits of embarking upon such a search. Partial matches in New York. And I'm convinced that employing an identical procedure for familial searching would provide appropriate protections and safeguards against any possible abuses. If additional precautions are thought to be needed, as a prior speaker mentioned, there could be required training by the laboratories of those receiving the results of a familial search lead to be sure that they understood what the lead does and does not represent. Significantly, the handling of partial matches in New York over the last half-decade has shown that these types of simple measures will be sufficient to guarantee the thoughtful and appropriate leads, appropriate use of these leads. It is our hope that the Commission on Forensic Science will act expeditiously to authorize the use of familial DNA searching to solve cold cases here in New York. Depriving the citizens of our state the benefits derived from this scientific tool is not only poor public policy, but defies all reason. The solving of the murder of Karina Vautrin was the result of persistence, not luck. If you wish to call it luck, then you must concede that the Nypd made its own luck by turning over 1 million stones until they turned over the right one. Yes, it was in essence a stroke of lightning that led to the arrest last weekend. But we cannot always rely on a strike of lightning to solve crime. And we shouldn't rely on it when sound scientific tools exist. We need to use all the tools at our disposal and make no mistake. Without prompt action on familial searching, killers, rapists, and those who perpetrate other violent crimes and serious offenses will remain at large, the public will remain in danger, and the suffering of other victims and their families will be amplified by the inability to solve their cases. Justice demands that law enforcement be provided every lawful means at its disposal to identify the perpetrators of crime and to bring them to justice. We owe the public nothing less. If the Commission fails to act on this, how would we explain to other parents like the Vautrinos that while we had the means to prevent their loss, we lacked the will to do so? I thank the Commission for its time.
Thank you. Next speaker is Professor Aaron Murphy.
Thank you for the opportunity to address you all today in this special joint session. My name is Aaron Murphy, and I'm a professor at NYU School of Law. I'm a national expert in the field of forensic evidence, and in particular in the use of DNA in the criminal justice system. My book, Inside the Cell, came out in 2015, and one chapter of it is devoted specifically to familial searches. It's challenging to speak after the heart-wrenching comments offered by the Vautrin family and their supporters. I have 2 children myself, and I cannot begin to fathom the pain that they've been through and the injustice of the loss they have suffered. Although I'm here to speak against familial search methods, I want to acknowledge the courage it takes to speak out after enduring such tragedy and say that my heart goes out to their family. I will start by saying plainly that I am not here because I think familial searching will never work to find criminal perpetrators. In Ms. Vautrin's particular case, it was the hard work and sharp minds of the extraordinary detectives of the New York Police Department that get the credit for tracking down this suspect and making an arrest. But I fully recognize that in other cases, it may be a familial search that cracks the case or solves the crime. But the question today is not whether familial searches can ever work to solve crime. They can. The question is whether familial search methods comport with our fundamental values and constitutional principles. And the answer is, they do not. Familial searches take one entire class of citizens, the fathers, sons, and brothers of convicted offenders, and turn them into suspects. We don't treat the fathers, sons, and brothers of crime victims that way. We don't treat the fathers, sons, and brothers of members of our military that way. We don't treat the fathers, sons, and brothers of police officers or lab employees that way. And we don't treat the fathers, sons, and brothers of missing persons that way, even though we have DNA databases for all of those groups of people as well. And yet somehow proponents of familial searches believe that the state can single out the fathers, sons, and brothers of convicted offenders for treatment as possible criminals. I disagree. I think those relatives are equally deserving of the full protection of our laws as the relatives of anyone else, and that the people of New York should not endorse a law enforcement technique that would hold otherwise. Familial searches effectively allow law enforcement to skirt around laws that strictly limit the class of people from whom a DNA sample may be demanded by the state. Since its inception in 1994, the state law requiring collection of DNA from convicted persons has steadily expanded, and now it compels samples from all convicted felons and nearly all misdemeanors. Other states draw their lines differently, and a case involving DNA collection from arrested persons went all the way to the United States Supreme Court, where it was hotly contested and decided in a 5-4 opinion. These debates reflect the conflicting sentiments in our society about citizens having to hand over their genetic information to the state. To some, it is no big deal. But to many people, perhaps now more than ever, there is a deeply felt desire to keep one's genetic information private. Maybe it's a fear that law enforcement would abuse information readily available in a forensic DNA sample, such as learning that a person's sexual identity in genetics does not match their sexual identity as they live it in the world, or disclosing that a parent or a child is not, in fact, a biological relation. Or even in a political environment where country of origin suddenly matters more than formal legal status, revealing information about personal ancestry. For others, the desire to keep their genetic information private from the government may be born of a libertarian skepticism of police power generally, and a heartfelt belief in the right to be left alone so long as one does not engage in any suspicious or criminal behavior. Whatever the case, these hard-fought battles over the proper targets of DNA profiling reveal that people do care about who is on the government's naughty DNA list, and they expect, if they don't do anything suspicious, to get a place on that list, to be treated, along with everyone else in our society, as belonging on the nice side. Familial searches upend this belief. They put the relatives of convicted offenders on the naughty side of the ledger, and simply on the basis of a blood relation. To be treated as a criminal suspect is a serious matter. It can result in the loss of a job, estrangement from a spouse or child, alienation from one's community, and a mar on one's reputation from which a person in our internet age may never recover. Consider a man from Louisiana who became a suspect as a result of a familial search using a database associated with the Ancestry.com website. For weeks, the suspicion that he had committed a brutal rape and murder hung over his head. He worried police would shoot him or his dog when they came back to make an arrest. He had to explain the situation to his girlfriend. He had to work through the emotion that was stirred within him by his father's decision to voluntarily submit this DNA to what he believed to be researchers, which led to him falling under this cloud of suspicion. When finally the results came back that cleared him definitively, He was relieved, but even today, a Google search for his name turns up the whole sordid affair. Far from a harmless investigation, this fishing expedition, fueled by Familial Search, caused real pain. In this respect, Familial Searches are like poor quality, unreliable informants, although they come dressed up like 21st century high-tech help. Whereas an informant tells a law enforcement officer, "I think I know who did it," a Familial Search says something different. A Familial Search says, "Here's 15 people. None of them are your guy, but they all kind of look like the guy who did it. Go poke around their families and see what you find." If Familial Search is like an informant, it's a bad informant. Or to take the analogy of the partial plate we just heard, it's like running the partial plate not in the DMV database of all plates, but only in a list of plates of people related to convicted offenders. What is more, this informant ideally, an informant is unbiased. An informant tells you what's been said or done based on all the available information. But Familial Searches see only one sliver of the population. Familial Searches aren't looking for the usual suspects. If anything, that's what an exact match in a DNA database would do. Familial Searches are not even as precise as dragnets, like a sweep of the DNA of apartment dwellers after there's been a building with a recent theft. Those kind of searches create suspicion-based groups, people who have committed crimes in the past, people who have physical proximity or access to the scene. From those pools of suspicion, a search for DNA matches are done. In contrast, Familial Searches pluck one segment of the population, people with a biological and social relationship to criminal offenders, and treat them like possible suspects in any and all unsolved crimes. But there's nothing otherwise suspicious about those relatives. There's nothing that distinguishes them from any other person in our community. The suspicion brought down upon them is purely a function of the state's convenience, that the state happens to have their family member in its DNA database that it chooses to search. Now, some people think, well, it's okay to single out the relatives of convicted offenders because crimes run in family. In response, I would say first that the scientific research on that is not clear. Second, I would say in New York, it's a bit of a straw man. New York's DNA database contains the profile of all convicted offenders, all felons, and almost all misdemeanants. That means that even if crime does, in fact, run in families, many of those members will have a DNA profile in the DNA database, and a family search is not necessary. An exact search will do. But even if we were to accept that people born into families with convicted offenders are more likely to commit criminal acts themselves, some of which will go undetected, what is the suggestion here? That somehow we can treat those people differently as a matter of law? That the presumption of innocence or the right to be free from unreasonable searches and seizures embedded in our Constitution does not apply the same to them? Although there may be some people who believe we ought to distinguish between the way we treat people based on whether or not they're related to convicted persons, nothing in our law says the government can do that. Importantly, too, the Familial Search informant is a racially biased informant. It's not just that the state is selecting an arbitrary group of relatives to place under presumptive suspicion. It's also that this group will be disproportionately people of color. The exact racial breakdown of the state DNA database is not known. But using corrections data as a rough proxy, we can assume that it's roughly half African American and a quarter white and a quarter Hispanic. In contrast, New York State is approximately 60% white, 14% black, and 18% Hispanic. There's a dramatic disparity between the demographics of the state and the demographics of the convicted offender database. As I'm sure you all know, there's much debate about the reason for this disparity and about the role that race and ethnicity play in the path an individual travels to a conviction. But thankfully, resolving that debate is not important to my point here. What's important is that when the state chooses only the convicted offender DNA database to run familial searches in, it's inflicting its harm on those relatives, not just on an arbitrary basis, but on a potentially discriminatory one. Now, there are some that will say that the harm of familial searches is trivial, and that they do not, in fact, meaningfully compromise the rights of these relatives, or if they do, that such a sacrifice is small in comparison to the important public interest in identifying and convicting criminal offenders. But if that is the case, if familial searching is such an important, effective method and only minimally intrusive, then we ought to optimize its value and diminish its discriminatory impact by conducting familial searches in all government DNA databases. If the idea is that the privacy and liberty interests of these relatives are not compromised by these searches, or that the interests of law enforcement outweigh those concerns, then surely that's true for familial searches in the state's missing persons DNA database, in the DNA databases for victim profiles, in the DNA databases for victims in New York of 9/11, or in the DNA databases for lab employees or police officers. Surely there's no reason why the relatives of those persons need protection or deserve protection if the relatives of convicted offenders do not. Indeed, I would ask you as a panel to inquire of the people who speak in favor of this technique whether they do support familial searches in all available state DNA databases. I expect some will say they do, but if the answer is no, then I think the next question has to be, on what basis could the state arbitrarily distinguish between the relatives of people in those databases and the relatives of people in convicted offender databases? Ask them why this technique is so critical to law enforcement that one class of relatives has to sacrifice some of their freedom, and yet we don't seek the same sacrifice from identically situated other groups. Ask them why we should brush off these searches as not terribly intrusive when it's one group of relatives under presumptive suspicion, and yet indefensibly intrusive when it applies to another group. Ask them to clarify where in the law it says that you have less protection from the government based on whether you're related to a lab employee versus a drunk driver. The appeal of familial searching is strong. The appeal is strong of any method abstracted from its consequences when executed in the field that can solve horrible crimes and prevent future offenses. But the decision to authorize a law enforcement method that de facto diminishes the equal rights of a segment of our population on the basis of a blood relation and nothing more should not be undertaken lightly. The related decision to open up the genetic information of those relatives, when we as a society have thus far rejected a population-wide DNA database as a fair trade for crime solving, and when genetic knowledge is in its infancy, but genetic fever runs high, is perilous. Respectfully, this commission, which is neither democratically accountable nor staffed with the kind of expertise, moral, ethical, constitutional, that would be necessary to make this kind of political determination wisely, is not the right place to authorize such a momentous proposition. Convicted offenders in New York give up their genetic privacy by law by virtue of having been convicted of a criminal offense. Their relatives do not. Thank you.
Thank you, Professor. Next, we have from the New York Police Department, Deputy Chief Emmanuel Katrinakis. Thank you.
Good morning, Chairman Green, members of the Commission, members of the DNA Subcommittee. I am Deputy Chief Emmanuel Katrinakis, Commanding Officer of the New York City Police Department's Forensic Investigations Division. On behalf of Police Commissioner James P. O'Neill, I wish to thank you for the opportunity to speak with you today, and thank you for the opportunity to provide a statement in support of familial searching. The investigatory value of familial searching cannot be overstated, especially in cases without witnesses, fingerprints, and video evidence. This powerful scientific tool can help identify suspects who commit violent crimes while also serving as a safeguard aimed at avoiding wrongful convictions by identifying the actual perpetrator as well as exonerating the innocent. For over 10 years, familial searching has led to the identification, arrest, and conviction of hundreds of violent criminals, often in some of the most gruesome crimes, including murder and rape. When a felony offender is identified and brought to justice, additional acts of violence are likely prevented and fewer innocent people are victimized. But the power of familial DNA searching does not stop there. Familial searching can bring justice and thus some semblance of closure to victims and their loved ones. For these reasons, the NYPD is a strong proponent of familial searching. In the noteworthy Grim Sleeper serial killer case in Los Angeles, familial searching was the only investigative tool that provided a lead to investigators, resulting in the identification of the Grim Sleeper, Lonnie David Franklin Jr. The Grim Sleeper was responsible for at least 10 more murders over an 18-year period. Imagine if this type of science is available to investigators in such cases after the discovery of the first victim. Imagine how many lives could be saved and how much suffering can be prevented. In 2004, the U.S. Justice Department published a report that concluded almost half of all prison inmates surveyed reported having a close relative who had also been imprisoned. Usually this was a sibling, primarily a brother. Data such as this supports the belief in and bolsters the efficacy of familial searching to produce valuable leads. To date, when used successfully to identify a perpetrator, courts have not ruled to suppress evidence based solely on familial searching. There is no scientific or legal reason to believe that familial searching cannot provide the same truth-finding evidence that the criminal justice system has relied upon using conventional DNA comparisons for decades. In 2009, New York State adopted regulation permitting DNA laboratories to report to law enforcement and the district attorney's offices genetic near matches or partial DNA matches. A partial DNA match occurs when a DNA laboratory uses the Federal Bureau of Investigation's Combined DNA Index System software to search a crime scene DNA profile in the database for an exact match. But instead, a candidate offender is produced unintentionally that is near but not an exact match. These partial matches can be used by investigators to find the individuals who left DNA at the crime scene. The CODIS software is specifically designed to find a direct match, which is completely different than familial searching software to find close relatives of the perpetrator. CODIS-generated partial matches and familial search-generated near matches report the same information, the name of a convicted offender that is genetically related to the crime scene DNA profile. It is well known in the forensic community that familial searching software is superior to CODIS when seeking to find a close relative of a DNA profile, and familial searching success rates are significantly greater than CODIS-generated partial matches. The NYPD investigative model delineating investigative actions from a CODIS partial DNA match and a familial search DNA near match would be precisely the same. This investigative model is a carefully controlled process carried out by a small number of detectives with the exclusive responsibility to investigate leads produced by familial DNA searching. I'll take a few moments to discuss the NYPD partial match program investigative model. When a convicted offender's name is obtained by the NYPD, the commanding officer of the Forensic Investigation Division initiates a partial match investigation and oversees the investigation throughout the investigative steps. The first step is to build a family tree for the purposes of identifying biological relatives. Once a family tree is established, each relative is evaluated and a process of elimination occurs. Family members can be excluded based on a variety of factors, such as gender. In other words, the gender of the relative is different than the gender of the crime scene profile. The age of the family member, for example, a toddler, would be eliminated. The whereabouts of a family member when the crime was committed, for example, an individual living in a foreign country would be eliminated. The physical ability of a family member to commit the crime, a lifelong paraplegic, wouldn't be considered. Or the inability to commit the crime based on the family member being incarcerated at the time the crime was committed, as well as other logical elimination factors. The case detective would then initiate the collection of DNA exemplars from the remaining relatives that are not eliminated. Investigators then await comparison results from the DNA laboratory. The laboratory analyzes and compares the crime scene DNA profile to each relative's DNA exemplar profile to determine if there is a DNA match. If a DNA match is reported, the investigators employ traditional investigative methods utilized in a direct DNA match. This may lead to an arrest or elimination of the relative as a suspect. Every investigative step is controlled, deliberate, lawful, and sensitive to the privacy of all involved. Since the inception of the partial match program, no contact has occurred between a convicted offender and the NYPD. Trained investigators are acutely aware of disclosure prohibitions, such as familial relationships with the convicted offender. Appropriate investigative steps were carried out, and the vast majority of family members identified in the family tree were excluded from record searches and non-DNA information. A significantly smaller number of relevant family members were then excluded based on a DNA exemplar comparison to the crime scene evidence profile, with the exception of one case in the Bronx. In the Bronx case, the DNA from a brother of a convicted offender matched a cigarette butt collected from the crime scene. Subsequent investigative steps revealed the brother was lawfully present in location and was eliminated. In each case, the NYPD acted responsibly, always ensuring the constitutional rights and civil liberties of all involved in the investigative process, while always remaining steadfast in its diligent pursuit of justice for the innocent crime victims. Regulation. 11 states in the United States utilize familial searching, each with their own set of regulations. The policies and regulations governing the way familial searching may be done in New York State could likewise be calibrated to best serve the public in New York State, drawing on the vast experience from the numerous jurisdictions utilizing this significantly proven method. In the event familial searching is adopted in New York State, the regulations and policies must take into account the importance of an expeditious turnaround time, from the point of the request by law enforcement to a return report or a named person back to law enforcement. The NYPD has 4 recommendations. The first, New York State should solicit feedback from other jurisdictions that use familial searching, in particular, regulatory components and administrative steps that may be considered inefficient and unnecessary. Secondly, the crime type should not be restricted by regulation. Victims of violence, sexual assault, and other traumatic crimes should be entitled to familial searching to help find their assailant. Law enforcement should have the right to apply discretion to request familial searching based on the best interest of the public, as the way they are trusted to do with other investigative tools. The NYPD acknowledges that resources are necessary to conduct familial searching, particularly YSTR analysis. However, these costs are de minimis in contrast to the cost to law enforcement and DNA laboratories when familial searching is not available to solve cases. Third, although familial searching success stories are cold cases or cases that remain unsolved over a span of time, without question, familial searching can also aid in solving hot cases or fresh cases. Sometimes investigative leads can be exhausted rather quickly, and an expeditious familial search to solve a fresh case would have significant crime prevention value. Lastly, there may be instances when Y chromosome typing cannot be accomplished due to low quantities of DNA, or because a female DNA profile is one of the 2 profiles genetically related. Regulation should permit the release of the convicted offender's name if the established statistical threshold is satisfied without YSTR confirmation. In the event the Commission votes to authorize familial searching of the New York State DNA Index System, the NYPD respectfully requests that the Commission explicitly authorize or take a formal position of no objection to individual New York State DNA laboratories conducting familial searching against local DNA databases. Conducting familial searching in the local database would undoubtedly prove valuable investigative leads to solve violent crimes that the New York State database may not. Recognizing that many suspects in the local database are not in the state database, The inability to perform familial searching through the local databases would undoubtedly lead to missed opportunities in our attempts to identify violent criminals, exonerate the innocent, and prevent crime in New York City. A recent study revealed that a remarkable 10% of unsolved homicides in 2016 may be solved if familial searching were available. The following are just two cases that I want to talk about among the many where familial searching may help solve. The first case is a rape. On a February afternoon in 2015, a 12-year-old female was traveling on her way home from school in the Tremont area of the Bronx. Wanting a better life and education for her daughter, her mother enrolled her in a school that required her to travel over 3 miles each day via 2 separate buses. On this particular day, the child traveled upon the first bus, reaching the transfer stop where she would wait for her second bus. At the bus stop, she was approached by an unknown male who grabbed her arm. The male stated, "Don't scream or I'll kill you." Observing an object that she believed was a knife in the male's pocket and fearing for her life, the child complied. The male led the girl away from the bus stop into an alley and sexually assaulted her. A few weeks later, a male DNA profile was generated from the victim's sexual offense evidence collection kit. That did not reveal any existing offenders in the DNA database. 2 years later, the perpetrator has not been identified, and the victim's case remains unsolved. We should endeavor to identify this child sex predator through familial searching if given the opportunity. The second case, on the early morning in May 2012, an 18-year-old female was walking home in the East New York section of Brooklyn. When the victim was 1 block from her home, she was approached from behind by 2 unknown males. One male informed her that he had a gun and placed an object to her head. Giving her instructions to walk into an alley, fearing for her life, the victim complied. Once in the alley, the males pushed her against the gate and forcibly raped and sexually assaulted her. The victim reported the incident to the police, and a sexual offense evidence collection kit was collected at the hospital. DNA results from the kit identified the perpetrator's male DNA profile did not match any existing offenders in any DNA database. 5 months later, an attempted robbery of a 29-year-old male occurred in the same East New York section of Brooklyn. The victim was parking his vehicle when a male wearing a mask and carrying a firearm ordered him against the nearby wall. The perpetrator attempted to bind the victim's hands with duct tape. When a violent struggle ensued, the perpetrator fled the location after the unsuccessful robbery attempt, but left the duct tape, his mask, and a sweatshirt behind. The DNA profile on this sweatshirt matched the DNA profile from the May sexual assault. Both cases remain unsolved. The ability to utilize familial searching in this case could stop this violent recidivist before he strikes again. In conclusion, familial DNA searching, in a few words, uses valid science to get to the truth. The men and women of the NYPD remain steadfast in their mission to protect and serve the public, and to that end, to tirelessly investigate and solve thousands of crimes each year. They should have access to every valid scientific tool that can assist them in this endeavor. Thank you for your time.
Thank you. Our next speaker is New York State Assembly Member Stacey Pfeffer Amato.
Hello? Is that working? Okay. Good morning. My name is Assemblywoman Stacey Pfeffer Amato, and I represent the 23rd Assembly District, which includes the Queens neighborhoods of Howard Beach, Ozone Park, Lindenwood, Broad Channel, Hamilton Beach, and the Rockaways. I'm also a lifelong resident of the Rockaways, where my husband and I are raising my 2 children. First, I would like to acknowledge the Commission on Forensic Science and the DNA Subcommittee for holding this hearing regarding whether to authorize familial DNA testing to be used in criminal investigations. I would especially like to recognize my colleagues, District Attorney Richard Brown and State Senator Joseph Piedabo, for their tireless efforts to bring justice on behalf of the Vautrin family. Finally, I would like to acknowledge the incredible men and women of the NYPD who, through diligence, creativity, and hard work, have enabled the Vautrinos to at least move a few steps forward from one of the darkest episodes in our memory. As you may know, last August, our community lost a vibrant, young, and beautiful soul in Karina Vautrino. She was only 30 years old. Karina was a daughter, avid runner, and graduate from St. John's University. Karina was attacked by a ruthless killer in a remote, wooded area of Howard Beach, Queens. Last week, the NYPD finally arrested a suspect who was alleged match for the DNA collected at the crime scene. But for 6 long months, the Vautrinos had to wait. It wasn't because police didn't use every tool in their arsenal to catch the killer. They did. And they eventually got their break. But it's unconscionable to wait to deliver justice when it can be quicker. Familiar matching is a tool we can immediately implement that would speed up justice, which is better for everyone. The victims' families, the neighbors who live in terror of a free suspect, even people who committed no crime and can be exonerated. Traditional DNA searches only look at exact DNA match, while familial DNA testing searches allow authorities to expand such a search to effectively include relatives who are already in the searchable criminal database. 10 states currently use familial DNA testing, one of which is California. Recently, FM allowed for the conviction of a murderer of Karen Klaus, wife of Bill Medley of the Righteous Brothers. Seeing the success of other states have had with this type of DNA searching in prosecuting dangerous criminals, it is incumbent upon the state of New York to follow suit. As a mother and a daughter, I know too well that 1 out of 5 women will be sexually assaulted in their lifetime, and how it scars the victim, the victim's family, and everyone in the community when it occurs. The injury is 10 times worse when violent criminals evade justice. Perpetrators of sexual violence are less likely to go to jail or prison than other criminals. As an elected official, I am dedicated to putting criminals behind bars and exonerating the innocent. That starts with making sure we can search the data we have more efficiently. There is much work left to be done. I have submitted this testimony today at the Commission of Forensic Science and the DNA Subcommittee to provide, on the behalf of my constituents, a request to allow the use of familial DNA testing in the state of New York. I believe that it will be a powerful investigative tool in making sure violent people are behind bars, innocent people walk free, and we can clearly differentiate between the two. I urge you to pass this measure as soon as possible. Justice in New York, to find, convict, or free, is already slow. You can act as soon as possible to make it quicker and more reliable, and I strongly encourage you to do so. Thank you so much for your time today.
Thank you. Our next speaker is Bob Perry from the New York Civil Liberties Union.
Good morning.
Good morning.
Thank you for the opportunity to address the Commission. My name is Bob Perry. I'm the Legislative Director with the New York Civil Liberties Union. This is a complex issue and undertaking, and I will attempt to do some justice to the complexity. I have submitted revised comments to the Commission, revised only in a technical sense. The substantive analysis is not changed, but those have been submitted as of last night. I will not go into great detail regarding those comments already provided. I will summarize them briefly, and then I would like to spend the balance of my allotted time addressing, I think, an underlying assumption or a conceptual kind of frame for this conversation that I hope may be helpful to the Commission going forward. So in short, my the NYCLU's 3 concerns regarding the familial DNA searching proposal are these. First, I think it's quite clear as a matter of law that the Commission on Forensic Sciences and nor the Department of Criminal Justice Services has authority under law to authorize familial DNA searching. Regulatory enactments must be in harmony with statute. Rules and regs must be promulgated only to the extent they are consistent with the will of the legislature, and state law does not authorize nor does it anticipate the use of DNA profiles from the state's data bank to facilitate criminal investigations of persons based solely upon the fact their DNA is similar to a family member. The second point we make, and I'll provide an illustration of this, so I'll just address it in very brief. The proposed familial searching policy does, in fact, pose serious risks to personal privacy, to the rights of individuals whose DNA is held in the state's data bank, and to the family members of those individuals. Now, the Second Circuit, the courts have developed a carefully crafted, well-defined test for evaluating the constitutionality of a statute that authorizes the state to retain DNA profiles of individuals who have been convicted of certain predicate offenses. And this analysis is based upon the state's maintenance of a DNA reference regarding offenders in order to facilitate criminal prosecutions or investigations should those persons reoffend. The court's rulings in the Second Circuit do not anticipate or authorize familial DNA searching. And as I said, I'll illustrate what may seem like an abstract or hypothetical interest, this privacy interest, but it's a quite real concern. And as I said, I'll have a case example in a moment. Related to the privacy concern is an issue raised by Professor Murphy, and that is there are serious systemic racial and ethnic disparities that play out within the criminal justice system in all manner of criminal investigations, but particularly when you engage partial match or familial match searching. It's well documented there are gross racial and ethnic disparities in the nation's prison population. These racial disparities do not necessarily reflect higher rates of offending among those groups in the general population. However, to the extent there is racial bias and ethnic bias in the criminal justice system, the use of forensic DNA databanks will have a tendency to exacerbate the bias. The third point we make in our comments is that prior to proceeding with this proposal to authorize familial DNA searching, the state government officials, the commission, law enforcement generally must undertake a really systemic analysis of what's required to maintain sort of airtight oversight and accountability regarding the use of forensics across the board, including DNA. That point, too, I think will become clear as I proceed. Now, as to this kind of conceptual framework or assumption that I referred to, I'm going to read an excerpt from a book by Sheldon Krinsky and Tanya Simoncelli. They are authors of a book called Genetic Justice. It looks at DNA databanks as used in the criminal justice system. In their book, they address in particular the notion that the scientific method and the judicial system are analogous in certain ways, as the way they approach what they call fixing belief. And they begin by observing that both the scientific and legal community seek the truth, albeit in different contexts. They then argue that both systems, legal, scientific, operate within certain norms, checks and balances regarding accuracy and precision. And they conclude this observation, this analysis by saying the following. Although it may seem there are stark differences between the pursuit of truth in science and in the judicial system, both are embedded in a social context, and as a consequence, the methods they use share some common features. Fraud can be found both in science and in legal processes, where evidence can be cooked, fabricated, withheld, discarded. Scientists who violate the standards of research integrity are usually publicly censured or ostracized from the community. Penalties imposed on police for the mishandling of evidence may not be as severe as those given to scientists charged with misconduct, but evidence mishandling can reverse a conviction and weaken the public's trust in the prosecutor. Just as there is scientific misconduct, there is prosecutorial misconduct. The authors, Simoncelli and Trimsky, are scientists. They're not lawyers, they're not litigators. And I believe, although there are certain foundational analogies that are sound in their analysis, there are some fundamental differences as well. And I think they understate some of these differences between the criminal justice system and scientific research. Scientific scholarship, inquiry may be highly competitive, there may be dishonesty, there may be unethical behavior, but there are important differences in the culture of scientific research and criminal investigation and prosecution. The legal system is adversarial by definition. It is, in a sense, a contest. There is a winner and a loser. A case or trial is won or lost. Rules of procedure and rules of evidence are used entirely lawfully and within the bounds of criminal procedure to include or exclude information or evidence from a jury. But scientific method is very different from motion practice in criminal prosecutions. And this contest is often susceptible to political influence, particularly in certain high-profile cases, playing out under the scrutiny of the larger society. District attorneys, after all, are elected officials. The stakes in this contest over guilt and innocence can be enormously high for the careers of the adversaries, and most important, for the liberty interest of the accused. And it is in this culture, the adversarial contest of criminal prosecution, it's in this culture in which that familial DNA searching will come into play. Now, Prinsky and Simoncelli conclude this analysis by observing that contemporary philosophers and historians of science have shown that science can be too easily idealized. And this notion has been taken up by an academic named William C. Thompson in an article called DNA, the Gold Standard, in which he raises questions about the perceived infallibility of forensic DNA. And I want to add here, in response to some of the earlier observations that have been made, the fact that I'm raising issues of privacy or due process as a constitutional matter does not mean that we at the NYCLU are Luddites. Forensic DNA is an extraordinarily precise forensic tool. We're not arguing that point. But I will take up that point where William C. Thompson takes it up. He observes under optimum circumstances, DNA evidence is extraordinarily reliable. However, the collection and analysis of DNA evidence is a human endeavor. It is susceptible to human fallibility. And he has documented an unexpectedly high incidence of error and fraud in the collection and handling of DNA evidence. Mishandling of samples, cross-contamination of samples, misinterpretation of results, misrepresentation of results. And he's documented these problems across the country, including in the lab of the New York City Medical Examiner. So I said I would provide an illustration as to what this privacy interest is about. And I'll just give one case example from an article by William C. Thompson, and this is by no means an anomaly, this example. This is a case coming out of Tulsa, Oklahoma in 1993. It involved Timothy Durham. He had been convicted of the rape of an 11-year-old girl. He was sentenced to 3,000 years in prison. The prosecution presented 3 pieces of evidence against him: the young victim's eyewitness identification, testimony that Durham's hair was similar based on a microscopic inspection or examination to hair found at the crime scene, and a DNA test that reportedly showed that Durham's genotype matched that of the semen donor. Durham presented 11 witnesses who placed him in another state at the time of the crime, but the jury rejected his alibi defense. Post-conviction DNA testing showed that he did not share the DQ alpha genotype found in the semen. He was also excluded at several other genetic loci in multiple tests. The initial DNA test result that helped convict Durham was proven to have been a false positive. So what happened? The error arose from a misinterpretation of the DNA sample. The laboratory had failed to completely separate male from female DNA during differential extraction of the semen stain. The victim's alleles, when combined with those of the true actual rapist, produced an apparent genotype that matched Durham's, but was not Durham's. The laboratory mistook this mixed profile for a single source result, and thereby falsely incriminated an innocent man. Durham was released from prison in 1997 after spending 4 years in prison for a crime he didn't commit. And so what I'm offering here to the members of the commission is a cautionary tale. Advances in DNA technology have outpaced the advances in the oversight and accountability needed to ensure precision and accuracy. Lawmakers have massively expanded the state's DNA data bank. The commission has already authorized a partial match policy regarding the use of lower stringency DNA searches and analyses. The NYCLU has raised in the past concerns that the development of policies and practices regarding the use of forensic DNA has not given sufficient consideration to the potential harms to fundamental rights and liberties, to the innocence of people who are wrongfully prosecuted and convicted, to the integrity of the criminal justice system that has done terrible damage when someone is wrongfully prosecuted, as happened in the case of Durham. And we raise the same concern now regarding the proposal that New York authorize familial DNA searching. Thank you very much.
Thank you. Our next speaker is Assistant District Attorney Robert Biancavilla from the Suffolk County District Attorney's Office.
Chairman Green, members of the commission, thank you for having us here today. My name is Robert Biancavilla. I'm the Deputy Chief of the Homicide Bureau in the Suffolk County District Attorney's Office. I have been an attorney for over 30 years, most of those years as a prosecutor and most of those years as a homicide prosecutor. I have had a ringside seat to more human tragedy than I care to remember up to this point in time. I'm a veteran of the original DNA wars and have fought many of the battles in order to implement the use of advancements in DNA technology over the years. I'd like to take just a more practical approach to my presentation today to give you an understanding from a prosecutor who uses this on a day-to-day basis in order to solve cases. Out in Suffolk County, since 1960, we have over 200 unsolved homicides in our county. That's 200 families, just like the Vautrinos, who to date have not had any closure in the cases that they've experienced. What we're looking at, or what we're looking for as prosecutors and investigators, are leads. Evidence that will point us in the right direction. Evidence that will point us not only to potential suspects, but evidence that will assist us in essentially getting away from people who aren't potential suspects or who shouldn't be potential suspects. I've come here today, I'm about to begin a double murder trial. The murder of two young women that occurred in the 1990s. I've taken time away from that trial preparation because I think the issue that you're considering here today is probably one of the most important forensic issues you're going to deal with. This case that I'm about to begin resulted from one of those leads that I'm speaking of. It was a partial match lead, a lead that was generated through DNA, through the DNA database, which resulted in a partial match. We were provided with information that essentially said that a person whose DNA profile that was contained in the DNA databank was a partial match to DNA that had been recovered from two young women that were killed in the 1990s. Both of these young women were brutally beaten and strangled to death. Both of these young women were found naked in the woods in Suffolk County, and both of these women essentially were positioned in similar fashions. There was reason to believe that the same individual committed these crimes. We were given this partial match, given information regarding the partial match, and the investigation began quietly, without disturbing anyone other than conduct background on the individual from which the match occurred. It let us know basically that this individual had two brothers. We focused on these two individuals without causing any disturbance in the community, without notifying anyone in the community. And we were able to obtain DNA profiles from these two individuals. One of them turned out matching the unknown profiles that we found on our murdered victims. That's as simple as it is. There's nothing complicated about that. There's nothing complex about that. It's as if any other lead was given to the police department, any other lead was given to an investigative agency, and they responded to that lead. That's what we do. That's what we do in law enforcement. Whatever type of lead it is, wherever it comes from, we investigate it. Familial searching is just the ability to provide us with another lead. I had another partial match experience in my career. A little different. We had a woman who had been brutally assaulted, sexually assaulted in her home back in 1998. In that case, the police were targeting a specific individual who was an inmate at our local jail. And the police were fixated on the fact that this was their guy and they wanted to effectuate an arrest. We had a DNA profile. I said, take a deep breath and let's see if we can get a DNA sample from him. When the inmate was released from the Suffolk County Jail, the Nassau County Jail, we served the Nassau County Jail with a subpoena, as crazy as it sounds, for everything that was contained in that inmate's garbage pail when he checked out. We got a toothbrush out of it. We took the toothbrush, we ran it for DNA, they came up with a profile. And again, they told us, close, but no cigar. Does he have a brother? So that essential piece of DNA information, or partial match, if you want to call it, exonerated an individual because it turned out his 16-year-old brother was the perpetrator of this sexual assault. Again, very simplistic approach to the use of the technology, but that's what we do as prosecutors, and that's what we do as investigators. Two cases in my career, over 30 years. Shouldn't be. Not in the 21st century, folks. We have the opportunity to implement familial searching in New York State. People are talking about this being a novel, a new technology. It's not. This technology has been here or been around for 10 years. People with cases, families, are entitled to have closure. I'm currently working on a 1984 homicide. Occurred before I even graduated from law school. 25-year-old girl, much like Karina Vatrano, brutally raped and murdered. Her body was dumped naked in the middle of a street in a residential area of Suffolk County. 1984. There are thousands of hours that have gone into the investigation of that case, and that case, 30-plus years old, is still under investigation. Exemplars from suspects, potential suspects, have been taken. Interviews continually conducted. Probably in the past 7 years, over 1,000 hours have gone into the investigation of that case. we have a single source DNA profile found on that victim that we have been unable to match to anyone in the CODIS database. Evelyn Patel is her name. A lovely young woman who at 25 years old was brutally raped and murdered. Her family still sits today waiting for an answer to what happened to her. We as prosecutors and investigators look to solve these cases. And we are not naive to the fact that many cases will go unsolved. But if we have evidence and we have the technology that can provide us with an investigative lead that could lead us ultimately to the killer of Evelyn Patel, I want it. I want it. I want to be able to use it. Because this is the 21st century, and this is the kind of technology that we use in the 21st century. Now, New York State, again, in this state, it has slowly taken incremental steps to expand the database and the use of profiles contained in the database. Again, this technology is 10 years old. It's unfortunate that our public officials have done little to rapidly take advantage of the technology as it becomes available. There are other technologies which are not, this is not the proper forum to address them, that the state also has not taken advantage of in terms of giving us the tools that we need to do our job. Familial DNA searching is unequivocally one of the most important steps that must be taken in New York State to advance DNA technology. Failing to permit the use of familial DNA searching severely diminishes the value of advancements in forensic DNA technology. By utilizing familial DNA analysis, investigative leads can be generated at the earliest possible time in the most cost-effective manner and expeditious manner. The benefits to public safety of familial searching are unquestionable. Its ability to save countless lives and prevent unnecessary suffering is unparalleled in law enforcement. I thank you for your time.
Thank you. Our next speaker is from the Innocence Project, Susan Friedman.
My name is Susan Friedman, and I am a staff attorney with the Innocence Project. First, I would like to thank the Commission on Forensic Science and the DNA Subcommittee for the opportunity to speak with you here today. The Innocence Project is a nonprofit legal and criminal justice reform organization. We work to exonerate the wrongfully convicted through the use of post-conviction DNA testing, and we work to develop and implement reforms to prevent wrongful convictions. To date, in the United States, there have been 349 post-conviction DNA exonerations. Of those individuals who have been wrongfully convicted, on average, they have spent 14 years in prison for crimes that they did not commit, with some spending nearly 40 years in prison. And cumulatively, these individuals have spent 4,762 years in prison for crimes that they did not commit. Of the 349 DNA exonerations in the United States, 149 actual perpetrators have been identified. And of those, 147 have gone on to commit additional crimes. In New York, there have been 29 post-conviction DNA exonerations with 11 actual perpetrators identified. Preventing wrongful convictions obviously has public safety implications. As an organization that has demonstrated its ability to work in conjunction with law enforcement and prosecutors nationwide to identify the true perpetrators of crimes, we have carefully considered these expansive DNA search tools. Indeed, the Innocence Project has been involved in a case where we have paid for DNA testing, and our local counsel were lawyers that were considering the use of familial searching, but we have not been involved with that effort. The Innocence Project supports the use of validated and reliable forensic science techniques, as many of our clients have inappropriately become the focus of investigations when there has been a misapplication of forensic evidence. One underlying theme of the proponents of the fast implementation of familial searching is that the state DNA index system is full of violent criminals, and violent criminals have family members who may have committed violent crimes. The New York State DNA index system includes profiles of everyone convicted of felonies and penal law misdemeanors. It is critical to note that the database contains a multitude of profiles derived from people who are convicted of crimes that are nowhere close to violent, such as selling MetroCard swipes. Familial searching uses innocent people as a starting matter of an experiment that may, but is not guaranteed to result in the identification of the true perpetrator of a crime. That these techniques implicate innocent people is a critical concept that should define this conversation moving forward. We cannot lose sight of the fact that familial searching will target many innocent individuals. The harm to them is real and must be considered by this commission. These individuals will be wrongfully targeted, their privacy will be invaded, and they will suffer the stigma associated with being a suspect in a violent criminal offense. The Innocence Project supports valid and accurate criminal investigative tools and remains unconvinced that familial searching will bear the promise that has been attached to it, considering its impact on the innocent, privacy, ethics, and criminal investigations. However, if familial searching is to be implemented, it cannot go unregulated, as many of the proponents suggest. This should be the beginning of a discussion that involves all relevant stakeholders, and transparency in the development of the ultimate policy is paramount for public confidence. If this tool is to be used, it must be applied in a way that meets ethical and legal requirements, which must include the following. First, any familial searching program must be authorized through legislation. The New York Civil Rights Law prohibits genetic tests without a person's consent unless authorized through the DNA databank. Because of the serious privacy concerns and harm to the innocent, questions regarding familial searching are better left to the legislature. Legislatures are uniquely capable of considering and reflecting various concerns when making such decisions, including how the negative collateral consequences of the use of this tool can be minimized. Additionally, legislative action fosters public debate in a manner far more robust than executive action or simple deference to law enforcement decision-making. The bill must include provisions that explicitly set the criteria for cases that qualify for familial searching, which includes but should not be limited to the following. First, the crime is either a murder or felony sexual assault. Second, a DNA match would provide significant evidence of guilt. Third, similar to and keeping in mind that CODIS is currently expanding to 20 loci, that consideration should be kept in mind, and subsequent YSTR testing be implemented where appropriate. And local DNA databases, such as ELDIS, which are not expressly authorized by statute and are unregulated, must be destroyed and should not be used for investigative processes, as they likely contain DNA profiles of individuals who are not in Estes because they have never committed a qualifying crime. Individuals are entitled to privacy with respect to their genome, and as the databanks expand, the addition of familial searching essentially creates a universal database. Judicial review must be a component of the legislation and require the least intrusive means of investigation. If law enforcement and the district attorney determine that a case is a candidate for familial searching, then an application should be made to a judge. It is insufficient for determinations such as these to be made without judicial oversight. Judges should review the cases to ensure that all other investigative leads have been exhausted, that the law enforcement agency has made a showing that the least intrusive means will be used both in DNA testing and process and in its investigative strategy. Police have an established deadline for submitting DNA samples provided by individuals identified in familial search for analysis and must seek extension, which should be granted for good cause only. Police should be required to report back to the court on the results of the search and investigation. All scientific and non-scientific investigation units are conducted at the state level, with the release of the identity of the perpetrator to the local investigators only upon approval of state authorities. The officers investigating the leads generated by Familial Search have been trained in methods to enable them to not disclose familial connections and agree not to do so. These trainings should be created in consultation with experts in ethics and the law. And if a DNA reference sample is collected, that DNA profile may only be compared to the case at hand. The DNA profile may not be compared against other unsolved crimes or uploaded to any database. Law enforcement will destroy the biological material and DNA profile of all of those investigated but not charged with or not prosecuted in a stated time frame. The Innocence Project makes these recommendations because strictly defined limitations are needed to prevent DNA dragnets and reduce the number of innocent people ensnared by this process. Repeated targeting of a population will rupture trust between a community and law enforcement. Detectives and investigators rely on local communities to assist in solving crimes. And when trust is broken, the value added of familial search will be eclipsed by the loss of investigative leads offered by a community and can have a chilling effect on the public's confidence in law enforcement. Further, genetic dependence will lead investigators to using familial search as a first option rather than non-forensic investigative techniques that may be time dependent. The legislation should authorize data gathering and reporting to a public advisory committee. The state must report search metrics and investigative results to a public advisory committee that can evaluate the efficacy of the program against societal costs. Therefore, the bill should sunset in 3 years. We need to handle the invasion of people's genomes with great respect. A sunset provision will force us all to evaluate this program and decide if it is worth renewing as time and technological advances could change this calculus. Unless these standards are specific and measured, familial searching could become a waste of limited law enforcement resources, an impediment for police investigations, and a legal liability. Innocent people and victims deserve accurate and reliable evidence, and the people of New York State require that any burdens placed on them and its citizens must serve justice in the long run. At present, the New York State Commission on Forensic Science is not fully seated. It does not include a representative from the Assembly, the private bar, and most importantly, privacy or bioethics as required by law. We've established today how complex this issue is, and we believe that it requires more deliberation. We appreciate that lawmakers are drafting legislation and trying to approach this issue in a measured way. The bill introduced by Assemblymember Magnarelli is a good start, but it requires many more oversight provisions. We will be happy to serve as a resource and believe that the proper approach is to convene all relevant stakeholders to define substance and scope of such oversight. Solving serious crimes is appropriately a top priority of our government, but it must be considered alongside similarly important concerns about resources, racial disparity, burdens on innocent, and constitutional rights that are also implicated by these tools. Indeed, a proposal that fails to deliver its promise may actually have the perverse effect of misdirecting limited criminal justice dollars and not actually solving crime at the scale intended. It may be that those limited dollars are better directed towards other crime-solving measures. In my closing remarks, I would like to reiterate to this commission that innocent people will be put at risk with familial searching, and the impact on their lives will be significant. Thank you.
Thank you. Our next speaker is New York State Senator Joseph Adabo.
Good morning. Good morning, Chairman Green, Commission, Subcommittee. Thank you very much for your time here today as well, and for giving me the opportunity to express my support for the use of familial DNA in our state. We already know that 5 district attorneys in our state favor familial DNA to be used in investigations. We do know, and we heard today, that law enforcement also favors familial DNA to be used in our state. Our own NYPD Commissioner, James O'Neill, favors familial DNA to be used in our state. But I've also found community support for familial DNA in our state. I have here a letter from Community Board 10. Community Board 10 in Queens is one of the most diverse community boards in the city.
It represents the area of Howard Beach where Karina Vautrin lived and was brutally murdered. It's an area that I represent as well, and they unanimously support, by a way of a vote, familial DNA to be used in our state. We also know that familial DNA for over the past 10 years have been used by more than 10 states successfully to arrest suspects, to successfully exonerate suspects and avoid wrongful convictions. California, since 2008, has been using familial DNA, as well as other states. And since 2008, ironically, is the same year that Maryland and the District of Columbia banned familial DNA. But if we look at how technology has changed, I'm sure in the field of forensics, since 2008, we see that we are in a far better position to use familial DNA now than we were back then. But I don't like to compare New York to other states. We are so unique. So therefore, when looking at this issue of familial DNA and considering my support for it, I looked at it as a separate issue. I looked at it in the reality of the world in which we live. I looked at it as we have technology today. And I also looked at the issues that we have with it that have been attached to familial DNA throughout the years. I believe if administered correctly, the use of familial DNA can ease the privacy concerns when looking at using it for extreme felonies during investigations, when all other investigation leads have grown cold and failed and fall short. Unlike fingerprints, which have a broad database of unconvicted individuals, DNA has a certain select database of convicted individuals. I also understand that when initial searches are done, the initial search doesn't know anything about the person being searched, no race, no names. It cannot actually specify a specific gender, or I should say specific race to be searched. So therefore, in my opinion, familial DNA actually avoids racial profiling, since we do not know the person who's being searched. Today we have the ability to avoid future murders and rapes, felonies, by those who still walk out there, those suspects who are still out there. We have the ability to stop future crimes. I believe we have an inherent duty to properly protect our public and their families. While legislative process up in Albany has progressed a little bit with this issue, I also believe that this commission and the subcommittee has within its ability to properly regulate familial DNA and use in our state, to safeguard it and address the concerns that have been attached with the issue, and still give our law enforcement the scientific, investigative tool that they need. I respectfully request that this subcommittee and commission consider using familial DNA in our state for the sake of our public. Thank you very much.
Thank you. Our next speaker is New York State Senator Phil Boyle.
Mr. Chairman and members of the commission and subcommittee, thank you for the opportunity to speak before you. I'm New York State Senator Phil Boyle. I represent the 4th State Senate District out in Suffolk County. I've been involved with DNA-related legislation for over 25 years, since I was a congressional staff person, and actually read Joseph Wambaugh's book, The Blooding. I can tell you that the time is now for familial DNA searches to be brought. We need to give law enforcement every available tool, and it would be a travesty if we did not use this latest technology, not even really new technology, to be brought to New York State to stop violent criminals and protect our citizenry. I actually thought that we were doing familial DNA until I saw a press conference by Mr. Ventrano, the Ventrano family, following the tragic death of their daughter, and it would be a fitting tribute to Karina to bring familial DNA searches to New York State to protect victims in the future. Just a few of the cases you've heard about: the Grim Sleeper serial case, LED Kulik, a case in France, used familial DNA. It was Denver, I believe, police department that did the search, and Karen Class, among others. I happen to represent Gilgo Beach, where we have a serial killer that's never been caught out there. I don't know the DNA, what's out there, or if there is any, but potentially that serial killer could be caught as a result of familial search as well. I recently, after speaking to Mr. Ventrano, drafted legislation, and it has support of Senator Adaba, who just spoke, Senator Ravella, and Assemblywoman Pfeffer Amato was the assembly sponsor. That bill allowing familial DNA searches in New York State passed the New York State Senate last week, by an overwhelming bipartisan majority, 49 to 10, almost 5 to 1. There were Republicans, there were Democrats, there were liberals, there were conservatives, all supported the idea. It's limited, and I do believe there needs to be limits to those situations where the crime is violent, where there's only one source of the DNA profile, and all other investigative leads have been exhausted. I'd like to quickly address the issue of privacy that has been discussed today. Well, I can tell you that any law enforcement official can tell you that any case has suspects. High-profile case will have many suspects. No one is going to be convicted, of course, on a familial DNA search. That's simply lowering the number of potential suspects to get the person quickly. As far as the race issue, Brad Jenkins, the forensic biology program manager of the Virginia Department of Forensic Science, has been quoted as saying DNA is blind to race. You have a DNA type, and you're simply trying to find a match for that DNA type. The time is now to bring familial DNA searches to New York State. We're going to catch violent criminals. We're going to end cold cases finally and end the suffering of families and protect future potential victims. I thank you for the opportunity of speaking.
Thank you, Senator. Our next speaker is Greg LaBerge, Director of Forensics and Evidence Division, Denver Police Department.
Good morning.
Morning.
I'd like to thank the committee and the people of New York for having us here today, me specifically. I'd like to start out, my name is Gregory LaBerge. I run the Forensics and Evidence Division for the Denver Police Department. I'm also Assistant Professor of Medical Genetics, University of Colorado Anschutz Medical Center. I'd like to start out with my condolences to the Chano family. We're here for you, and also to the other victims. We work for you every day. The Denver Police Department stands with you and with the people in New York, as we have since the beginning of our cold case program in 1999. I want to kind of discuss the history with you as to how familial searching came to the United States, because it started with a commitment to victims. In 1999, we recognized quite early that STR technology that was just burgeoning, coming to age in the United States with the CODIS database in around the late 1990s, was going to have a dramatic effect on the criminal environment in the United States. We launched our cold case program in 1999 in Denver. We did it with the citizens of Denver support, with overtime money for the police department, and we actually searched some of the cases that we had run the older DNA systems on that weren't as effective in a data bank format. The first case that we chose to run was the sexual murder of a young woman who was a bartender in the Red Lion Hotel near the old Stapleton Airport. That was the very first case we put in CODIS as part of an STR program, and it hit, the very first one. At that point, we realized the power of this technology. We knew that we had to throw all in and not forget the victims of crime and move forward. In 2003, we started to get federal money for our cold case program. To date, that cold case program has examined or administratively reviewed over 5,500 sexual assault murder cases in the city and county of Denver. We've had over $5 million of support through a lot of hard work by a lot of dedicated people in the state of Colorado and the city and county of Denver. Of those 5,500, we had about 1,100 of them ended up in the crime lab for testing. We're almost done with the project. To date, we have about 434 matches on the database. We've uploaded 900 profiles from those 1,100 cases. That means there's 450 profiles that have not matched. When I took over as director of the crime lab, 2005, we made a commitment to modernize forensic science and forensic science investigations in the city and county of Denver on many fronts. We looked to leaders in the field. The leaders in the field at the time were in the United Kingdom. 2006, we took a trip, myself, former District Attorney Mitch Morrissey, who's here and will address the panel, and my boss, Deputy Chief David Fisher, Division Chief David Fisher at the time. The UK government was gracious. The Home Office brought us around the country where they introduced us to leading edge forensics around the United Kingdom. One of the things we learned quickly from them was they were applying familial DNA searching through the Forensic Science Service in Birmingham. Upon return to Denver, we made many changes in terms of our forensic operation. We increased our efficiency greatly through a process called the Scientific Work Improvement Model, where we basically looked at business processes and that were inefficient and we made them efficient. We made turnaround times drop dramatically by an aggressive business process approach to forensic science. Because we're part of a major police department, we changed the way detectives investigate and follow up on forensic leads. We changed our policies to require within 24 hours of notification of match. In DNA, APHIS, or Nypd, which is a shell casings database, the detectives had 24 hours to follow up on those matches. The reason for that is if we're going to put all of this effort and funding into forensic infrastructure, detectives must follow up in a timely manner to get resolution to these cases. So we not only changed our forensic process, we changed the detectives and the investigative process that followed from the forensic one. That was key to the success in Denver. But we still were getting about a 50% hit rate on CODIS. Excellent system. We fully support the CODIS system and the FBI that brought it to the United States. But we also recognize that about half of the cases were not matching. So what do? Do you wait? We had 450 cases that didn't match. That's 450 victims, like you. We could wait. Everybody else waits. But we chose a different path. That different path was we chose to do something different. You can do something or you can do nothing. We chose to do something. We contacted Charlie Brenner from California, great guy. Charlie came out, he used the software called DNA View that was originally used on the World Trade Center disaster for linking familial connections for the human remains analysis. We worked with Charlie to understand, is it possible that we can adapt that software to DNA profiles that are kept at the state level and also at the local level. We worked with Charlie for about 2 weeks and decided that we could probably have a go at it ourselves. And within 3 months of hard work, we programmed the nation's first familial DNA searching system. The UK wanted a large sum of money for their product, which we didn't have in law enforcement at the time. So we decided to do it ourselves, American ingenuity. Took us 3 months of hard work. We programmed the first system. It was slow. It was very inefficient. But since then, we've been funded over $500,000 from the Department of Justice for research into this DNA research program for familial searching. And we have greatly evolved the system to what it is today. We've provided it to 8 of the 10 states that you've heard about. We've provided it to Australia for the country to do familial searching. And we do it out of a commitment to victims. In terms of success rates, we've done 15 familial searches to date. 15, but with thousands of profiles. We have about a 30% success rate. We have a strict protocol, which Mr. Morrissey will talk about in terms of how that was put into place in 2009. 30% of the people that we interrogate with YSTRs, which is one of our follow-up processes, actually matched. 30% of the time, we were able to get to the family and to get some information on the case. Not always leading to a conviction, not always leading to an arrest, but nonetheless giving us something we didn't have before because we did something. The city and county of Denver, like most cities, we have financial problems. We've been through some financial hard times. One of the things in government that we're asked to do is we're always asked to do more with less. That was the commitment. We have a commitment to the victims, a steadfast commitment to the victims. We're there for the victims of crime, to prevent future crime. But we're also on a very tight budget. We developed our familial searching system with funding through the Department of Justice on our cold case program, through support from the National Forensic Science Technology Center, through support from the Denver Police Department and the citizens of the city and county of Denver. That gift is the reason I'm here today, because I look at it like something that is my commitment as a forensic scientist and an academic scientist to tell you it works. You can do something or you can do nothing. We chose to do something. We continue to do something. Our cold case project to date will be finished in about 8 months. That's 800 sexual assaults that we have put into the database. That's 250 homicides that we've looked at. That's city and county of Denver. We have 700,000 people last count. That's a small city compared to New York. But it's a big commitment. And what I'm asking you to do is follow us, help us. We followed the British. We followed other smart people. We listen to smart people. And when you listen to other people who have done something and tried, you get results. We have results. And those results help victims of families of victims. We stand with you. I can't say that enough because it's important. And this committee should adopt familial searching because it's highly evolved, it's effective. We've done a lot of hard work to understand the statistics, the population genetics behind it, to program a system that is effective and efficient and does more with the data that you already have. That data exists. The information to get these leads is in that data now, and it works. It's validated, it's extensively tested, it's provided worldwide at this point. But I wouldn't feel bad as a state that you're behind. You're not behind, you're progressive. There are 50 states, last time I looked, and if 10 have done it, you're still being progressive. You have our support as a state, Colorado. You certainly have our support as a police department, the people in New York, the NYPD, our chief, and me. I will stand beside you through this. I will provide technical support. I will provide continuing efforts to improve the system, provide you with expert guidance that we've been through that we needed, and make sure it's successful for you, for the people in New York. With that, I'd like to thank you for your attention. I'd like to thank the people of New York for having us here and reiterate my support to you. Thank you very much.
Thank you. We appreciate you traveling to be here and appreciate your offer of assistance. We are going to take a 30-minute break now. In fairness to both the people on the subcommittee and commission who've been sitting here and also to everyone in the audience. I very much appreciate the way everyone has conducted themselves so far. We're going to make it exactly 30 minutes, so we'll be back here and starting at noon. So again, thank you. take their seats. We're going to get started momentarily. Thank you. Our next speaker is from the New York County Defender Services, Brad Mauer.
Thank you for the opportunity to address this joint session. My name is Brad Mauer. I'm a staff attorney and DNA specialist with New York County Defender Services, which is a public defender organization here in Manhattan. As any observer of the criminal justice system knows, public defender organizations largely serve poor communities of color. And it is on behalf of those communities that I'm here speaking today, as well as on behalf of my organization. I want to begin by saying that we are very glad that representatives from so many venerable institutions are here today speaking out on behalf, against the authorization of familial searching. Because there are so many ways in which the proposal, if it is even specific enough to be called a proposal, is deeply, deeply troubling for the communities that my office serves. I will not be spending any of my time here discussing the science involved in familial searching. I won't be digging into studies or statistics or weighing the efficacy of various proposals or protocols. The conversation about familial searching at this time in New York City is nowhere near that stage because New York must first grapple with the fundamental issues that this controversial subject raises. The first of these issues centers on why law enforcement wants to be able to do familial searching in the first place. Police departments and prosecutors say it will help solve crimes by generating additional leads. How? The answer is quite simple. Familial searching is a way for law enforcement to gain access to more people's DNA. The more DNA profiles they have, the more they can compare against the crime scene evidence. Obviously, the best way to achieve this particular goal is to have a universal DNA database where every person's DNA profile is in the database and they can simply search the crime scene evidence against the database with everyone's DNA in it. New York and society at large has rejected and continues to reject this approach. Right now, New York law says that the government is only allowed to put in the database the DNA profiles of persons convicted of certain criminal offenses. The law doesn't say the government can collect and use DNA from convicted offenders' relatives. So familial searching is essentially law enforcement's way of bringing into the database the DNA profiles of persons that the law does not permit them to collect and use in this way. It's as simple as that. And why law enforcement wants to include this particular group, that being relatives of convicted offenders, is an issue that I'll address shortly. The next fundamental issue is how will law enforcement execute familial searching here in New York? Well, familial searching by definition starts with a completely innocent person. It's a person previously convicted of a crime whose DNA profile does not match the crime scene evidence under investigation in the given case. If that person's DNA profile is nonetheless close enough to matching, the prosecutor and police will initiate an investigation into this person's family. They'll create a family tree. And the NYPD, as they stated before, is proud of the fact that since the implementation of the partial match program, no contact has occurred between a convicted offender and the NYPD. Now, pause for a moment to consider what methods must be employed without direct contact to put together a person's family tree. The particular people the NYPD wants to investigate from each family tree are, by definition, not in the DNA database. They haven't been convicted of a DNA-eligible offense, so they've given up no privacy interest whatsoever under New York law in their genetic information, and they've done absolutely nothing to invite police suspicion. Now, I keep mentioning the word investigate. What does that mean here? The police need a DNA sample from these convicted offenders' relatives, and there are two ways they can get it. They can either openly confront the family members as law enforcement and seek a DNA sample from them with the intimidation and coercion that often attends police interactions. Or they can secretly track those relatives in an effort to obtain a DNA sample from them without their consent. So the NYPD has offered no details regarding how they would obtain samples or how they do obtain samples, only that they will do so lawfully and responsibly. The central message here is just trust us. Once law enforcement has the relatives' DNA samples, what they're asking to be able to do here is to use those profiles for searches in both the state database and the local database kept by the Office of the Chief Medical Examiner here in New York City. Now, does this mean that OCMA would keep those convicted offenders' relatives' profiles forever and the physical samples forever? Does it mean that they would run these profiles against unsolved crimes in the local database in perpetuity? Because that's what OCME does now with the samples that they obtain from defendants. The NYPD and DA's offices are surely aware of the fact that the OCME database is essentially unregulated. And as they make clear in their submissions, they prefer as little oversight as possible in carrying out familial searching. Again, they are saying just trust us on this issue. Curiously, the NYPD in its written comments states that a database search using a relative's profile, quote, may lead to an arrest or exoneration of the relative. Now, of course, the word exonerate implies a pre-existing accusation or burden placed upon that person. In this case, it's the heavy burden of criminal accusation, often of a very serious crime, which the police themselves have placed there before lifting it. That burden of accusation can be enormous, and it can impact a person's profession, their personal relationships, and their sense of self. The next fundamental question here is who will be most affected by this unprecedented expansion of genetic surveillance? These investigations of convicted offenders' family members whom law enforcement has no reason to suspect other than what amounts to a hunch will put a hugely disproportionate burden on communities of color. The criminal justice system has created a massive racial disparity in the way poor New Yorkers of color are policed and prosecuted. So logically, their overrepresentation in the DNA database would be equally dramatic. Thus, the communities largely falling under investigation from familial searching would be those communities of color already disproportionately affected by the criminal justice system as it is. This kind of hunch policing in communities of color used to go by the name stop and frisk. Eventually declared unconstitutional, stop and frisk had a devastating impact on communities of color and their relationships with law enforcement. Now, instead of what's in your pockets, law enforcement wants to know what's in your DNA, all because a relative of yours was convicted of a past crime, and that relative, while known to be innocent of this crime, has a DNA profile which happens to be close enough to a match for police to knock on your door or stop you in the street or snatch your soda can out of the trash. Is this what passes for probable cause or reasonable suspicion now? The past crimes of your relatives? Prosecutors and police no doubt would say, that's not how we're going to do it. This will be nothing like stop and frisk. But nothing in the DA's or the NYPD's submissions here offer any reassurance whatsoever on this point. I said earlier that I was going to come back to the issue of why law enforcement wants specifically to bring convicted offenders' relatives into the DNA database. The NYPD cites a statistic that 48% of all prison inmates surveyed reported having a close relative who had also been imprisoned. Translation: we should assume that our unsolved crimes were committed by relatives of convicted offenders because those relatives, largely poor and of color, are more likely to have been in prison themselves. Never mind the studies I mentioned before showing that Black and Hispanic New Yorkers are arrested and convicted at rates entirely disproportionate to their relative share of actual crime. In other words, law enforcement arrests and convicts a certain group more than another group for crimes that both groups commit. And then later law enforcement wants to turn around and say the first group is more likely to commit crimes in order to justify investigating them disproportionately through familial searching. This logic is not only circular, but it goes against core ideals of our society. These poor communities of color, sure to be heavily burdened by still more law enforcement intrusion into their lives.
Just interrupt, I apologize, but it's important that nobody make any comments while our speakers are speaking. Everyone has the right to express their opinions without interruption, and we're going to make sure that happens. So again, I apologize for the interruption and appreciate you being here in your comments. Please continue, and we'll give you extra time.
I wasn't even aware of an interruption, but thank you very much. So as I was saying, this logic is not only circular, but it also goes against core ideals of our society. Now, these poor communities of color, which are sure to be heavily burdened by still more law enforcement intrusion into their lives, this time intrusion into the extremely personal domains of their genetic information and family relationships, deserve the chance to have their own voices heard before any action is taken with respect to familial searching. In a state where stop and frisk, Eric Garner, and Black Lives Matter protests are the recent backdrop, if prosecutors and police truly wish to take seriously their oft-stated commitment to ensure that all communities are policed and prosecuted in a manner that respects their dignity and hears their voices, law enforcement should stop and listen to those voices on this issue. Perhaps then law enforcement would come to recognize that familial searching is the opposite of respecting the dignity of communities of color. Creating a mechanism for treating the law-abiding relatives of convicted offenders as suspects whose innocence must be proved to law enforcement via exonerating DNA collection is the opposite of respecting dignity. Indeed, the Queen's DA's office in its written comments makes a point of asserting that, quote, innocent law-abiding members of the public who have provided elimination samples of their DNA in cases like burglaries and car thefts have no cause for concern because such profiles are not entered into or searched in the DNA databank. This is a stark admission by the Queen's DA's office that collecting DNA and comparing it against crime scene samples is a massive intrusion that would greatly upset those people. How can proponents of familial searching not recognize that relatives of convicted offenders, of course, share this same cause for concern? Yet proponents of familial searching would have the relatives of convicted offenders believe that there is no cause for concern in the first place, because familial searching is as much about safeguarding the innocent as it is catching the guilty. Now, if this was actually true, those innocent law-abiding people being reassured by the Queen's DA's office should be first in line to have their innocence safeguarded and the innocence of their relatives safeguarded by the use of familial searching. Instead, the Queen's DA's office wants to exclude those people, those innocent law-abiding people, from familial searching, and they want to include another group of innocent law-abiding people, those with a relative in the convicted offender database. If the Queen's DA's office had its way, the innocent law-abiding relatives of the convicted offenders would have their innocence safeguarded by the following procedures: police investigation into their family relationships, secret tracking and or direct police confrontation to obtain their DNA. In other words, increased police presence in their community designed specifically to treat them as criminal suspects. Comparison of their DNA against a crime scene sample by labs which are, put charitably, not immune from error or even fraud. Permanent retention of their DNA, possibly both the physical sample and profile, by those labs for comparison against local unsolved crimes in perpetuity. And this is where the local New York City lab's own internal studies have shown problems with contamination and transfer, thus, of course, risking false accusation in a future case. This is not a recipe for safeguarding innocence. This is not a recipe for respecting the dignity of innocent law-abiding citizens here in New York. This is a recipe for exacerbating the existing and toxic racial disparities that exist in the criminal justice system, further eroding already difficult relationships between communities of color and the law enforcement sworn to protect them, not suspect them. The information revealed and exploited by familial searching is some of the most intensely personal in existence. This is not like fingerprinting or license plates. When did a license plate ever reveal that a person was adopted or scientifically confirm an unknown biological relationship? More to the point, when did a non-matching fingerprint ever bring criminal suspicion upon someone's close relative? This is not even like prior expansions of the DNA database, where the legislature chose to include more crimes as being DNA eligible. This is bringing in a whole new class of people, by definition, innocent and undeserving of our suspicion. This is an effort to enact a massive and harmful change in the way law enforcement views and relates to already marginalized communities. New York should remain in the company of the vast majority of states that have not authorized familial searching, particularly those that have expressly forbid it. Thank you very much.
Thank you. Our next speaker is Rock Herman.
Commissioners, subcommittee members, thank you for having me here. As a native New Yorker, it's good to come back and help out with what I've done in California and elsewhere. We're here because of Phil and Katrina. Let there be no mistake. That's the only reason we're here. And so we need to pay attention to that and remind ourselves that they helped us get to this point. But by my account, there are about 54,000 other forensic unknowns in your state database that deserve consideration, that we ought to try to solve in a better way than we're using right now. Having lived through the whole DNA era, I can tell you we're at a moment where things are repeating itself. In the very beginning, the founders of the Innocence Project developed a scorched-earth policy against forensic DNA typing. When they realized that they had the opportunity to apply it in a different context, in the post-conviction testing contest, off they went to that. Well, we're back there right now. We're exactly back there now. It's another truth-searching tool that we can derive out of DNA. It's blind to whoever's using it. Is going to tell you whatever it's going to tell you, nothing more and nothing less. So when is that going to happen with familial searching? I believe the speaker from the Innocence Project mentioned there's one case that they're interested in. I have a feeling I know what case that is. Google Christopher Tapp, T-A-P-P, Idaho, and ask yourself whether the Innocence Project is serving their client, not everybody else that's spoken out against it, to see what's happening. If that's not the case, then I stand corrected, but that's an Innocence Project case. Not coincidentally, it's also the case that spawned that phony New Orleans filmmaker story that I'll talk about in a minute. So, what has been accomplished with deriving more benefit from the millions that we've spent on our DNA databases? Well, you, and I say you collectively, approved the partial match policy several years ago. But it was flawed because you didn't mandate the use of YSTRs to confirm or refute the question of close relatedness. It was known at the time that it was unlikely to solve any crimes, that it was somewhat likely to produce the false leads that those in opposition to familial searching have jumped on today, but you approved it anyway, and in doing so, it necessitated the kinds of direct contact that Manny described with NYPD. But what did they do? They do the job they always do, and they tried to make it work, and it rarely worked. Familial searching obliterates all those concerns. It's the right way, and I'll talk about anecdotally what's happened around the country rather than predicting the future. I'd rather learn from the past. But NYPD pursued it, committed untold resources to pursuing a flawed process because that's the only thing you gave them. We've heard a lot of opposition to this. It's the same song over and over again. I'm not going to rebut all of it except by talking about the step-by-step process. What's interesting is most of the written materials ignored the webinar series report that we produced. It's part of the record here. It's been available for 2 years. Ignorance of the past is inexcusable when you want to predict the future. Some of the actual entities that have participated in today's session and provided written materials were invited guests at those webinars, and they were given an opportunity to voice their concerns. And I think you should compare, for example, the Northwestern Center for Wrongful Convictions position about it versus the Innocence Project, whether they're in the same business trying to find out if someone's been wrongfully convicted. So the process is very simple. It's a two-step process. The first step in the process produces, it's a search ranking process, produces a candidate list of persons who are likely to be close relatives. Typically around the country, that's about 75 or 150 people. You can make it as big or as short as you want. The size of the list is directly proportional to the size of your state database. Step 2 uses lineage testing to confirm or refute whether the offender is in fact a close relative. These two processes are designed to only provide investigative leads pointing to true close relatives. The majority of familial search investigations to date in this country have not produced an investigative lead. I remember when we first plugged in CODIS, no one ever said this is going to work. We knew intuitively it was going to work, and when we talk about the success, you'll know not only intuitively, but anecdotally and empirically that it works. Experience has shown that virtually every investigative lead to date has led directly to the actual offender. Typically, the relative was very high on the candidate list. No false leads have been produced. No samples were collected from family members who were not the source of crime scene DNA, unlike the partial match policy that NYPD struggled to make something out of. The best examples of how things work are how they worked in the past. So the Grim Sleeper, it was one of the very first ones that we did in California. There was a candidate list, there was no concordant Y, there was no investigative lead, and at that point, what do we know? The son who led us to that, the next time it came up, was not in the database. So if you want proof that it's not going to find an unrelated person, look to the experiences we've had in the country rather than dire predictions of failure. Occasionally, and again, supporting the power of familial searching, there have been two concordant Y results. And to the best of my ability to follow up on those, in every one of those instances, it was actually a sibling of the person. In other words, it identified two siblings, no one else. So this stuff narrows it down and nails it. Most of the critics have said in writing and today that the false leads produced. And they use that phony story about the New Orleans filmmaker. I've written and submitted a summary of what it is. The New York Times is enamored with that story. So read over the truth of it, and Professor Murphy mentioned it again today. It's designed not to produce false leads, and in practice, it produces no false leads. Even if it were true, after 9 years, if all anybody could come up with is one false lead, I'd say the system and the process works really well. Among the 10 states using familial DNA searching, each state's protocol is fundamentally the same. There are a few different softwares being used. This is what's important. There is nothing about California's protocol, for example, that necessarily provides more protections than any other state's protocol. There are more words in it, but it's the process itself, the two-step process that provides the safeguards, not the words on paper that describe what they're going to do with it. Anecdotal success rates demonstrate that familial searching has been as efficient as CODIS, using CODIS success metrics. Using the 25% projection that's in our webinar final report, 25% times 54,000, we might solve 13,000 crimes if this is ever done in New York State. Even as Phil said, who's going to deny that one success wasn't worth the effort that we're going to embark in? There's nothing about familial searching that necessarily implicates anybody's Fourth Amendment rights. To put it another way, whatever Fourth Amendment rights existed before familial searching, they still exist today. Legal challenges are available to question law enforcement's actual use of the investigative leads, as they have always been. For example, if you followed the new NYPD's follow-up on partial matches, everything that they did was open to Fourth Amendment scrutiny throughout the whole process. Another example is the Grim Sleeper 2, the one that was successful. And during our webinars, we invited the criminal defense attorneys to say, at what point is somebody's Fourth Amendment right implicated in this process? So the second time, the successful time, search rank, one concordant Y, was number 3 on the list. You could see from the genetics, the allele sharing, that it was a father-son. The investigation was this complicated. These are old cases. It couldn't be the relative in the database because he's too young. Look at the dates of the crime, surveil the father, follow him around lawfully, and collect his sample. He had a right to litigate the seizure of the sample in the restaurant, watch the videotape. That litigation occurred during the trial. He lost his motion to suppress. He's on death row. One of the statements, another that the New York Times is enamored with, and this goes back to the story about a week ago, the legal implications of familial testing, namely whether it is limited by the Fourth Amendment's prohibition of unreasonable search and seizure or the 14th Amendment's Equal Protection Clause, have not been tested in courts. Now that sounds like something important. If I said to you, I've never dunked a basketball, I hope you don't think that I'm going to go home tomorrow, hit the playground, and dunk it. The real point is there is simply no cognizable legal issue, no challenge that can be raised against familial DNA searching. That's why it hasn't happened. We pay our capital attorneys by the hour. I watched some of that trial. They didn't miss anything during that trial. There has never been a legal challenge to familial DNA searching in all the cases that have been solved, especially the ones that have gone to trial, and 3 of them occurred in California. Of the 10 states using familial searching, none sought legislative change. Clearly, their laws didn't anticipate familial searching. Clearly, that was not part of people's consciousness at the time. What each and every state did, they looked at the legislative purpose that authorizes their database, and they said familial searching produces investigative leads, which is the legislative purpose behind each and every state's database. So the opponents have said, oh, it must be legislatively authorized, and then the other side of the coin is that there are all these constitutional defects. You cannot legislate away people's constitutional rights. People are whipsawing 2 things together to make this seem much more daunting than it really is. The familial search process itself is race blind. Any investigative lead is based on genetic and familial relatedness, not on race. They don't care whether you're purple or not. If the DNA says that's a close relative, the way it has in each and every one of these cases, that's what gets pursued. When Katrina was murdered, we had no idea the race of the person. And I wish we'd been able to use it to solve the crime, because when the relatedness is proven by collecting a sample, you don't care what the race of the person is. Now, here's where things get interesting. The absence of familial searching as a law enforcement tool has encouraged and increased the use of DNA dragnets throughout this country, something I'm opposed to and something I think the people opposed to familial searching are opposed to as well. They never work. They heighten the danger with law enforcement or citizens. They cost way more than familial searching ever does. So the absence of this tool has really created a problem for law enforcement that they're going to resort to whatever's available. There's a secondary goal that I hope comes out of this. There's been some criticism of the lack of information. At some point, some national entity has to take charge of this. It shouldn't be left to individual states. That's just the way it's going right now. There's been a total void at the national level for anybody to encourage, educate, facilitate. Instead, you feel like you're reinventing the wheel because suddenly this came to you. And on a final note, I mentioned the 54,000. There's another jogger in Massachusetts, not that far away from here. They've shown no signs of having the public debate and discussion that feel forced to happen here. And so there's a lot riding on this, not only for you, for the citizens of New York, but for those other states who are balking, and I hope they're listening to this session today, at implementing familial DNA searching. New York carries a lot of weight in this country, and so I'm sure when you evaluate things, when you analyze where things stand, I will remain available to help you out as long as I can get a meatball sandwich the next time I come back. Thank you.
Thank you. Our next speaker is Allison Lewis with the Legal Aid Society.
Good afternoon. My name is Allison Lewis. I am a trial attorney with the Legal Aid Society, and I have been for 12 years. I've also been working for these past 4 years with our specialized DNA unit since we created it. The Legal Aid Society is the primary provider of indigent services in New York City, and we are considered the largest defense organization in the country. Today, in our comments, we are also honored and privileged to be joined by the New York State Association of Criminal Defense Lawyers, the Bronx Defenders, New York County Defenders, Brooklyn Defender Services, and Queens Law Associates. I want to thank the Commission and the subcommittee for hearing me today and for your time, and for everybody for sticking around this long, really. Thank you. When I saw that I was speaking towards the end, I thought surely I would be repeating what a lot of people have already very eloquently said, and to everybody's credit here today, I certainly have. I was right about that. Instead, I thought I would do a very quick roundup of the various positions on both sides, what we've heard in testimony, and what I've seen in the submissions for your review. Familial searching, as everyone here knows, is a technique that will utilize CODIS to look for essentially near misses. By definition, and as many predict, there will be numerous false positives requiring further testing, investigation, and then creating several possible suspects, and in some rare cases leading to an arrest and conviction. Obviously, a good outcome for society. So why do we and others oppose this technique? Why on earth would we stand in the way of even the smallest chance to find a perpetrator? Many who oppose this technique, including us, the Legal Aid Society, believe that these suspicionless searches are not a cause of no harm, no foul, or else all exemplars stored in the government databases would be searched, as others have mentioned, lab personnel, police officers, and even victims. Rights are violated, no matter how diffuse or petty they may seem to those who might be unaffected. We believe that no safeguards, no protocols can sanitize the patent unfairness to family members who may themselves actually be victims of these same convicted offenders. Nothing can undo the sting of speculation based only on relatedness to a wrongdoer, a stigma and burden certainly they already bear. To suspect only this narrow class of people, based not on conduct but on genetic association alone, is largely inefficient. If we as a society all feel that we want government to access our genetic information, that we are okay with this in terms of civil liberties, then we would create a universal database. But the New York State Legislature to date has explicitly rejected this. We submitted in our comments some minutes from the legislative history on the database. I think they very clearly reflect that rejection. And yet familial searching does allow, albeit indirectly, access to information of many innocent people by their sharing genetic information. People who live perfectly law-abiding lives. Perhaps people in this room. Familial searching could represent a very dangerous step towards selective genetic targeting, perhaps even the inevitable suggestion of genetic propensity. Pseudosciences in darker moments of our history, like eugenics, and phrenology come to mind. And while the intent of this practice is clearly not to directly target communities of color, as others have said, its effect certainly will. And anytime whole classes of people are separated off and targeted by the government based on who they are, or who they associate with, or who they are related to, well, that's a real constitutional problem. This disparate impact is a fact that cannot be ignored in this conversation. However, there's another side. Proponents of this technique certainly want justice for tragically lost loved ones and justice for other victims out there, and that is understandable. Some of the letters submitted believe there aren't privacy or constitutional concerns. They don't understand why we're having this debate. Others believe there are some compromises for privacy and civil liberties. But according to their statements, believe those policy or privacy concerns are de minimis when considering what hangs in the balance. Law enforcement representatives such as the Queen's DA's office, the agency that first asked this body to consider and authorize this technique, believe this practice would be, and I quote, sound public policy. Supporters believe the few success stories out there are so compelling, even just that one case that we might be able to solve. They believe that this last-ditch effort, this Hail Mary investigative technique is worth the costs associated, and that is ultimately an effective tool for the time and money and effort spent. But my point here today is to point out all of these voices that you've heard, all of these concerns, all of these passionate submissions for your consideration, these are all issues of public policy, issues that need to be balanced and considered by our elected officials in Albany. Very, very few of them, close to none of them, have really gone to the issue of the scientific validity of this technique. And I would submit that that is what these two bodies are here to consider. All the factors I described, the desires of victims' advocates, concerns from ethicists, civil liberties, worries from communities of color and other advocates that are actually notably not here because this is presumably a scientific forum, they should all go to Albany because this is policy. In fact, most of the letters ask this body to, quote, pass this law. Even the Queen's District Attorney's Office, in their advocating for sound public policy, goes so far to ask, don't implement those cumbersome procedures. Don't make us go through those loopholes and build new layers of bureaucracy, unduly complicating the process. Streamline it for law enforcement. Keep the restrictions on law enforcement light. But why is a scientific body asked to consider these issues? And what jurisdiction does this body actually have? I am just a trial attorney. I don't do legislative stuff. But I really wish somebody could tell me this. And I have read the executive law. I brought it with me. And I just really haven't heard any compelling arguments today. And I've been listening. It's one benefit of going last. I don't see it. I just don't. And I unfortunately read a lot of statutory language. Further, the executive law clearly does not give this body any power over the Queen's District Attorney's Office, or how they prosecute cases, or how their police officers investigate cases. There's just no way that this body, once authorized, can then tell the police or the district attorney's offices what to do, or more importantly, what not to do. As I prepared to speak here today, I struggled a bit with understanding exactly what this hearing was really about. The science, the protocols, the technique, or the policy and other issues. So it seems to me that you are asking us, the public, two things. One, and I believe it was even said in the introduction. One, should we authorize this policy, authorize this technique? And two, if we do authorize this technique, what will it look like, technically, scientifically? But I think these questions overlook the most important question, and that is, can we authorize this technique? And another question lingers. If we do authorize this technique with certain rules or restrictions, what if those rules are violated? What if they're abused? What if they're ignored? What do we do then? Now that Bill S-08216 has passed the Senate, and it will be reviewed by the Assembly, it is unequivocally clear that this issue has been must be and will be either approved or rejected by the legislature, specifically by the Assembly. There's no question they've taken up this issue in a timely and appropriate manner. So all of these voices, my own included, are misplaced here. They should be going to Albany. Whether this is constitutional, how will it affect victims and their search for justice, balanced also with the will and interests of society at large? Concerns, privacy, the sense of what's right. Is this something we want to do as a society? Will there be other consequences unforeseen? What judicial review, what limitations, etc.? All the things that people have brought up today, more questions than answers. And yes, even money, because that's what the legislature is charged with. Are the things that we do going to be effective enough to warrant us spending our limited resources? It must be the legislature that balances all of these interests. And if they don't do it to our satisfaction, we are able to fire them by not voting for them. Or if they pass a law that's ultimately unconstitutional, the courts will correct them. That is the balance of powers and our checks and balances. So who will oversee this body? How will society hold this body accountable? Ask yourselves, am I qualified to decide public policy for New York State? Am I in a position to understand and assess and balance all of the concerns, not just the concerns that have been raised here by this somewhat limited group of people who are interested in forensic issues? If that makes you uncomfortable, I submit that it should. We urge you to allow the legislature to do their job, defer to their expertise and resources on this matter. Not only is it appropriate and it makes sense given our governmental structure, but they will actually be answerable to society, and all the voices can weigh in. Once that happens, if they finalize this bill that's pending, then your role will ripen. And indeed, you must review this technique and give your scientific, valid, and very relevant opinion about how it is actually implemented, its validity, its parameters, and approve the way it's used in labs. I want to thank the Commission and Subcommittee for your time and consideration, and I sincerely do want to thank all the speakers for coming out today and everybody for sticking around. Thank you.
Thank you. Our final speaker will be Mitch Morrissey, the former Denver District Attorney.
It's always hard to hear that, but I am Mitch Morrissey. I am the District Attorney. I used to be the District Attorney of Denver. I'm recovering. I spent 33 years as a prosecutor. I spent 27 years litigating DNA. I spent the last 11 years studying the constitutionality and the legality of familial searching. I was on that trip that Dr. LaBerge talked about, where we went and learned from the UK. And what we learned from the UK was that they were very, very concerned about civil liberties with their program. And they gave us their policy, and they asked us to keep it secret. Eventually, we published it on our website. But that was one of their primary concerns, and we learned that that is a primary concern when you talk about familial searching. So we've been studying this. In 2008, we created the website the software that Dr. LaBerge talked about, and we've given it to the majority of the states that do familial searching in this country. We've given it to the Australians. They understand what free means. And we will make it available to your state at no cost. And we will support it the best we can. But use whatever software you want. Karina's family, thank you for the courage of being here today. For 33 years, I understand to some degree what you're going through. But thank God I've never lost my daughter. The software works. And Law Carmen talked about look at the policies. They're there. They're published. The great thing about going 11 is you don't have to break ground. It snowed a lot yesterday. You didn't have to break that snow. We've done it. Follow us. Write a good policy. Make this system work. The software works. We've proven it in Utah, where an older woman came home and was beat to death by a burglar with a hammer. And he left his DNA on that murder weapon. And through familial searching, they were able to give her family answers and that community answers. I can't promise you what case this software will solve, but it will solve one of these many cold cases. And this family, they don't have to worry about familial searching anymore, but I guarantee you there's a family out there, maybe listening to this hearing, that deserve the kind of answers that this family has gotten through the strong work of the NYPD. And I want to thank the NYPD. Yesterday we were here for almost 6 hours doing a training around familial searching, around what you do and don't do, around how it works. They're serious about doing this the right way. And that doesn't happen in a lot of the places that we've given it to. This software works throughout the world. And there's an awful lot of unwarranted criticism of this method. They say it's unconstitutional. I don't know how many of you are lawyers. I know some of you are. Listen, 33 years, I never once heard a public defender in Colorado get up and say, my client has an expectation of privacy in the sperm or in the blood that he left at the crime scene. Under the Fourth Amendment, he gave up that expectation of privacy because he didn't collect his sample and take it with him. So he has no expectation of privacy there. This search is done in a database he's not in. He doesn't even have standing there. It's done against a legally created database. We never charge the individual that's in the database, so they have no Fourth Amendment concern. But our concern was always what happens. Although this is all done anonymously, this is all done through code, we also use the YSDRs, and you have to have concordance there before the name's turned over. But what happens when you turn it over? Therein was our concern. What are the police going to do with this? Because there's the place where the Fourth Amendment can be violated. That's where privacy rights, that's where family rights, that's where those things can be violated. But you guys have already done that here. You have this partial match program, and you held the police to a standard that they know. That training yesterday was easy. These are people that know how to do this, and they do it in a very conscientious way. And the one thing I'll tell you, you got no concern handing this over to the law enforcement that we've dealt with here, because they've been dealing with these partial match follow-ups for so long. You have a huge advantage there. You have a trained law enforcement that knows how to do this kind of work. A lot of people throw around this exoneration thing, and I got to tell you, Mr. Harmon talked about the Northwestern Innocence Institute. They asked us to come to Illinois. They said they had a man that had been wrongfully convicted once, twice, 3 times. Juan Rivera was his name. Supposedly raped a girl and killed her. The problem was that the DNA they found in the girl didn't match Mr. Rivera. So he got a new trial. And he got convicted again. And he got a new trial. And he got convicted a 3rd time. And that Innocence Project, very well respected in this country, asked us to come and try to get the Illinois State Lab to do familial searching so they could find out whose sample this was, so they could know the truth and try to exonerate Mr. Rivera. That's how familial searching can help exonerate innocent people. We gladly went there because there's the murder of 5 women that were laid down in a dress store and executed. And there's a DNA profile in that case as well that we thought familial searching would help. I haven't gone through the cases of the NYPD. I don't know how many of those kinds of cases there are. But the sad thing is the Illinois State Lab told us no, both on Mr. Rivera's half and both on those 5 families that are still today waiting for answers. That's how it exonerates people. And the last thing that I want to talk about is this issue of overrepresentation, this issue of genetic profiling. Familial searching is not that. But when I go and talk about this issue, the one thing I do is I always look to see what the overrepresentation of people of color, victims of color, are in the community where I'm going. Because in this country, while African Americans are 13% of the population, annually, they're 50% of the victims of homicide. An African American woman is twice as likely to be the victim of a rape in this country than a white woman or an Hispanic woman. The great thing about New York is you keep great stats. So I Googled your stats. And in 2016, the victims of homicide in this city, if you add the African American percentage to the Hispanic percentage, was 91.3% of your homicide victims. And your rape victims, 74.8%. Now, DNA is a science that solves crimes. 90% of those violent crimes it solves, women are the victims of those crimes. Like this young woman that died in that park while she was jogging. Did you hear the common themes of the cases that were brought here? They were women and children. 90% of the victims of the violent crimes we solve in this country with DNA are women. And guess who the 10% that are left are? Majority are kids. This is a science that solves crimes against women and children. Familial searching helps that. The people of the state of New York have invested billions of dollars in this system. And I always say, you know, you built a Porsche and they want you to drive it like a VW Beetle. All this does is it makes it better. It doesn't violate people's rights. And to artificially create the constraint that's been called for by many of the opponents of this, based on racial composition of your database, should strike at the very heart of injustice. Because those women and children of color in this city, their families, if they've been victim of homicide, they deserve justice. They deserve to have a law enforcement agency look at their case, if there's DNA, to look at their case with the most updated technology that you have to try to get answers. I want to thank you for your work on this committee. It's my understanding that most of you do this as volunteers. I did see that you get a good free lunch, and that's a good thing. But this is important work. This is the first time in my years of doing this I have ever seen a commission called together to make this decision. And all I'd ask you to do is make the right decision here. Because families like this deserve the right decision. And the law enforcement people that you've heard from today will do this right, and they'll make you proud. Thank you.
Thank you. I would like to thank all of our speakers. Appreciate everyone's time and input. I'd like to thank everyone who submitted written comments. I know people have asked if anyone has anything in addition that they wish to submit to the DNA subcommittee and the commission for consideration. Please feel free to do so by the same method as submissions were made prior to this proceeding, and that's to send them by email to forensics@dcjs.ny.gov. That being said, on behalf of, not on behalf of, but with regard to the Commission on Forensic Science, I would like to make a motion at this time to refer the matter of familial searching, and specifically the issue of whether or not New York should employ familial searching, and if so, under what conditions, to the DNA subcommittee, for the subcommittee to consider those issues and make recommendations back to the commission, again, both on the issue of whether or not it should be employed in New York, and if so, recommendations with regard to what protocols and with what safeguards. If the DNA subcommittee does in fact recommend that familial searching should be used in New York State, I would also ask the DNA subcommittee to make recommendations with regard to draft policy or regulations for consideration by the commission. And I would specifically ask that they address issues with regard to relevant procedures and also safeguards. I would indicate as well that the Office of Forensic Services, I will make sure that they're available to assist the subcommittee in anything that they need or desire assistance with. Is there a second for that motion?
I second.
Is there any discussion with regard to the motion?
Quick question, Mr. Chairman. May we submit recommendations to the DNA subcommittee about protocols to be employed?
Yes. The comment I just made with regard to additional submissions would be open to everybody, both public and members of the commission. And anything that's submitted, we will make sure gets circulated to everyone on the commission and everyone on the subcommittee. Right. If there's no other discussion, I'd ask all in favor of the motion?
Aye.
Aye. Anyone opposed? All right, thank you. Is there anything before I ask for a motion to adjourn? Any additional business? All right, so maybe starting with the DNA subcommittee, is there a motion to adjourn? A second? All in favor? Aye. All right, so the DNA subcommittee is adjourned. I believe the next meeting of the DNA subcommittee is March 27th. With regard to the commission, is there a motion to adjourn?
So moved.
A second?
Second.
All in favor?
Aye.
Anyone opposed? All right, thank you. And again, I want to thank all of the subcommittee members and commission members. I know many people had to travel some great distances to be here. We appreciate your time and consideration.